Good morning. My name is Okimer Christian Dark. I'm the interim dean of Howard University School of Law, and we welcome each of you to the 10th annual Wiley E. Branton Howard Law Journal Symposium. We welcome those of you who are present with us today in the courtroom, and to those of you who are participating by way of the internet, as this symposium is being webcasted. We'd like to encourage all of you, or those who would like to also participate by way of Twitter. You can do so at HU Law Journal, and the hashtag is for this symposium is hashtag BrantonX. So let's get that conversation going throughout the day. In 1991, the law firm of Sidley Austin, this is the law firm that Dean Wiley Branton was a partner, established a scholarship ceremony to honor the 1L student who received the highest GPA at the end of the 1L year. And of course, this was a very fine and fitting way to honor the memory of and the accomplishments of Wiley Branton. But a conversation took place a little over 10 years ago. And that conversation, as I recall, was initiated by Professor Andy Gavel, a member of the Howard faculty, and at the time, the faculty advisor to the Howard Law Journal. And he had that conversation with Mr. Michael Nemeroff, partner of the Sidley Austin firm. And they talked about a full-day symposium that would be impressive, and hopefully an impressive, and it has been, tribute to the memory and the work of Wiley Branton. Mr. Nemeroff and his partners had a discussion about it and came back to support the symposium, and they have been supportive of the symposium from the very beginning. The scholarship ceremony is still a part of this symposium, and we will today honor the student who received the highest GPA at the end of his first year at lunch. These symposia have allowed Howard Law students to bring together legal scholars, practitioners, community activists, government officials, and thought leaders to carefully examine and engage in thoughtful debate and discussion about a topic that furthers the mission of Howard Law School. Now, what is that mission? Well, it's clear. Our mission is to produce graduates who are thoroughly prepared to continue fighting the good fight, that is, the fight for social justice. And they do so in any of the fields that they enter into. In addition, an issue, that is, a volume, is produced, a volume of papers, of the presentations from the symposium, every single year by the Howard Law Journal. And that is the spring edition of the Howard Law Journal. Now, it's kind of interesting because the planning for each symposium begins a full year in advance. In fact, shortly after this symposium ends, the planning committee for next year's symposium will come together and start to have a discussion about the theme. So over about a year ago, the planning committee selected this theme. I'm always impressed with the fact that they always manage to select a theme a year in advance that is so timely. And today's theme, civil rights at a critical junction, confronting old conflicts and new challenges, could not be more timely in light of the actions at the Supreme Court, what we see in Congress, and what we see in this country. Now, no program of this magnitude could be offered without a few important ingredients. First of all, you have to have a fabulous planning committee with really dedicated people, talented, good workers, and we do. And that planning committee is composed of faculty and students, but I will tell you that the engine of that planning committee are largely our students, and those are the students on the Howard Law Journal, and I'd just like to ask you if you would just raise your hand so that we could see you and acknowledge you and thank you in advance right now. Also, you need financial support. You need all kinds of support to put together a program like this. And we have had terrific support from our co-sponsors, and you will be hearing from them momentarily. Sidley Austin, Debevoise and Plimpton, the National Bar Association, and this year, the Lawyers Committee for Civil Rights Under the Law, celebrating their 50th anniversary. Thank you so much for your continuing support of the Wiley-Branton Symposium. The Branton family has been here every year. They were at luncheons for the scholarship ceremony, and they have also been here for every single symposium. And we are so grateful and honored to have them here again today. And so we welcome the Branton family. If you will join me in welcoming them, I'd appreciate it. From the very first symposium, we knew that we wanted to make sure that, particularly our students, really knew something more about Wiley-Branton than his extensive bio. We want you to know about his extensive bio and all of his accomplishments, but you know who he really was and get a good sense of his impact. The best folks to talk about Wiley-Branton from our point of view are his members of his family. And so every year we have someone from the family who speaks to us about Dean Branton, and that is the case this time. I'd like to ask you to join me in welcoming Mr. Marcellus Moore, Jr., the grandson of Dean Wiley-Branton.
Good morning, Howard University School of Law.
Good morning.
My name is Marcellus Harrison Moore, Jr., as Dean Dark said, and I'm the proud grandson of Wiley Austin Branton, Sr. As she mentioned, I'm joined here today by three of his children, Wileen Branton Wood, Wileen Branton Lamberson, Richard Branton, and a cousin of his, Carol Wiley. So thank you. And on behalf of those family members, as well as those who aren't here physically, but are here with us in spirit, thank you for attending and supporting this 10th annual Wiley Austin Branton Howard Law Journal Symposium. So when my Aunt Beverly asked me to give the family remarks, I really kind of had the mindset I was going to come up here and give a Russell Simmons-esque, thank you, God bless, and good morning. But then I kept hearing that I had this 5 to 7 minute guideline, and so I knew I wasn't going to get away with this short. I also learned, though, over the course of the last 10 years, we've had a history of family members coming up and giving strong presentations. So knowing that I'm going to see family members in about 4 weeks for Thanksgiving, I knew I better come up here and represent. So here I am, having been tasked with, as the program states, reflections on Branton. My challenge, however, is that my grandfather passed away before I was really old enough to appreciate what he'd accomplished, his legal successes. Sure, I'd heard the stories about the family growing up and having crosses burned on the lawn, death threats called into the house. I've seen the pictures with him and Thurgood Marshall and Dr. King. I've read the books about him, There When We Needed Him. But I never really had the chance to speak to him about his profession and what he'd accomplished. So I was kind of reflecting on how am I going to reflect on grandfather. And then what I realized after speaking with my aunt is that's precisely the perspective I should give, is he wasn't just the legal scholar that you hear about, he was grandfather. And it's especially relevant to me today. Here I am many years later, and I myself am now a practicing attorney in Chicago. I have 3 children of my own, and I intend to make my own mark on the world. So I come here today and speak before you in an event that honors my grandfather. And he's a man who was not only capable of being a grandfather to his 11 grandchildren, or daddy, as his children still call him, to his 6 children, but he was able to then go out and be chief counsel in one of the most significant civil rights cases in U.S. history. He went out and helped 600,000 voters register in states across the still heavily racist South. He served as executive secretary to President Johnson's Council on Equal Opportunity. He was the dean of the Howard University School of Law. He was a partner at Sidley and Austin. I mean, these are just among some of his many accomplishments. So although his name may not be one of the more commonly known names when you read mainstream history of civil rights, his accomplishments clearly impacted the history of this country and show me how one individual truly can make a difference. So fast forwarding to today, as Dean Dark mentioned, I think the topic and the theme of this symposium is right on time. Again, civil rights at a critical juncture, confronting old conflicts and new challenges. I think many people automatically, when they think of civil rights, reflect back and think of civil rights as something that happened in the 60s. But clearly it's an issue that should remain on the forefront of all of our minds. Again, as Dean Dark stole a little bit of what I had, but I think it's going to be a concurrent or a constant theme today with recent events, including the revisiting of the Voters' Rights Act, challenges to affirmative action, immigration reform efforts, same-sex marriage, and so many other civil rights-related topics. This is just a great time to address these things. And what it does show me is that one thing is clear. We still need individuals to be conscious of and to make a difference with regards to civil rights issues. At a reception last night, again, I think it was Dean Dark who specifically referenced the Voters' Rights Act. And here we are thinking that had been addressed some 48 years ago, and we're still having parts of it being invalidated. So I'm not here to talk through whether you agree or not with the majority decision of the Supreme Court, but what we can do today is talk about now what needs to be done to make sure that all Americans are afforded the same rights and the ability to vote. Who is going to take on challenges like that? And those are the types of issues that I'm looking forward to this event and today's panels discussing and debating. So with that, I hope that we can each take something valuable from this event and the series of sessions today. Now, I'm going to address this comment specifically to the students and the recent graduates that we have with us, but I think the message is applicable to everyone who's listening. Whether you're inspired to continue the legacy of Wiley Austin Branton Sr. or one of the many other civil rights leaders, past or present, or you're motivated by the fact that today an African American can be voted to the highest, most powerful office in the world, or maybe you're just driven by your own personal motivation and initiative, what I hope you can take from today is that civil rights continues to be an ongoing concern, and that any one of us can, and I hope that every one of us will, impact the future of civil rights for all people. So on behalf of the family of Wiley Austin Branton Sr., I would like to first thank Sidley Austin LLP for continuing this event. We recognize that your continued support and commitment is what has kept this event going on. So thank you, Sidley Austin. We also want to thank Howard University School of Law and the students of the Law Journal for hosting this event. Your hospitality has been outstanding, so thank you all for welcoming us here. Thank you to the Lawyers Committee for Civil Rights Under Law for co-sponsoring while celebrating its 50th year of protecting the civil rights of all Americans. And finally, thank you to Debevoise and Plimpton LLP. All right. I've been working on that more than any part of this presentation. And the National Bar Association for your support of this event. So with all that said, I leave you with the remarks I had originally intended to give. Thank you, God bless, and good morning.
Our Our next presenter, Mr. Michael Nemiroff, is a partner of Sidley Austin LLP. If I could create on the wall someplace a list of who the founders are for the Wiley-Branton Symposium, his name would be there. He has been a stalwart supporter of all tributes for, in any manner, for Wiley E. Branton, and for this, a stalwart supporter of this law school. So, Mr. Nemiroff.
Thank you. You know, I've been coming to this event, I've been involved with this event for more than 20 years, and this is the first time I've ever really spoken at a welcome at the beginning. And I do this without prepared remarks. My wife tells me never to do that, but I'm going to do that anyway. It's a pleasure to be here again. This is a wonderful, wonderful event. I'm surprised and delighted that it's been going on for 10 years. I'm surprised and delighted that I've been working with Howard Law School for more than 20 years. All you have to do is look at my face and know that I have learned a lot from my involvement with Howard Law School. The students, the faculty, the different experiences that you all have had have enriched my life in so many ways that I won't even begin to tell you how. So I thought I would tell you a little bit about how Wiley helped me and how a few thoughts that I have about what you can do in your careers as you begin to be lawyers in law school and after law school. So I practiced law with Wiley for 4 years at Sidley. He was fun to work with on a professional basis. He was much more interesting to listen to in partners meetings on a personal basis. He lectured us, and we needed it, and we grew from it, and we changed some because of Wiley being there. Practicing with him was interesting. He called me in his office one day, and there on the couch was Muhammad Ali. He had a problem, and I was able to help him with that problem that day, and I never would have had that opportunity had it not been for Wiley. I remember Muhammad Ali because I went to college in Chicago, lived across from Mosque No. 2 of the Black Muslims, saw Muhammad Ali as a young man, in his 20s really, around campus because he lived in that area. But to see him and to have the opportunity to represent him in a professional way was a great, short but a great experience, and Wiley gave me that. The thing that Wiley did as a professional, that I have done some of the same things, is he kept his practice always about the people, the clients. You know, the professional standards will talk to you about, will guide you really, about being loyal to your client and as an officer of the court, loyal to the system. And Wiley did that in remarkable ways. You know, you get there and you listen to your client, and it doesn't matter if it's a corporation or an individual or an association or a nonprofit. It needs to always be about that individual, at least part way. And if you keep it about the individual and about his or her problems, as well as the institution that he or she is involved in and that you're also representing, if you keep it about the individual first, you will have a good practice. You will have an enjoyable career. I know from my experience with Howard Law School that many of you most of you have not come right out of college to law school. Most of you have done lots of other things, both in work and in social activities, and have had many, many experiences that have shaped you. But as a professional, which you will become when you graduate from the law school, you will have the opportunity, you will have no choice as a matter of fact, but you will be inventing yourself as a professional over the next 10 or 15 years of your career. And you will be applying all sorts of things that you've learned before that to your practice, and you will make decisions about how much stress you can take, how hard you're willing to work, what kind of subjects you feel like you're good at and what you're not good at, who you like to work with and in what roles. And by listening to yourself in an honest way, you will make decisions about all of those things, and that's who you will become as a lawyer in, say, 10 or 15 years. And if you do that honestly, you will have, and you listen to your clients and you try to help them, you will have a wonderful time as a practicing lawyer. I've been doing that for 40 years. I don't have any wonderful accomplishments. I don't have a long list of things that I have done that the world would take as important, but I'm very proud of my practice, and I feel like I've helped people over the time I've been doing this, and I'm still enthusiastic about it in my late 60s and will continue it as long as I'm able, and I hope you have the same experience that I've had. Thank you very much.
Our next presenter is representing another one of our co-sponsors, Debevoise and Plimpton. Mr. Robert Williams is a graduate of Howard University School of Law and a former member of the Howard Law Journal. Mr. Williams?
Good morning. Good morning. I'm excited to return always to my alma mater, especially for Brenton. Unfortunately, I have to follow these two great speakers, so I'm going to keep it short and sweet. But I first want to thank co-sponsors, faculty, staff for putting this event on. Your attendance, support is very important. Debevoise and Plimpton, we're proud to be a part and take part in the legacy that's Howard Law Journal, the symposium, and the university and school in general. I think it's important, and I like to see that over the years, it's more and more students, more and more people from the outside have started to attend. I think it's very important considering that Howard is one of the birthplaces of social engineering. And I think the symposium is something that brings that spirit along and it lives on. So I want to make sure that I can do everything to make sure that that doesn't stop. And last but not least, I do have to point out the students because, as Dean Stark said, I was on the Law Journal, and I know the countless hours and library runs and thousands of footnotes that you pour over that you don't always, or everyone doesn't always know goes on. So short, sweet, thank you guys for having us, and proud to be a part.
Patricia Rosier, who is the president of the National Bar Association, is running a little late. Chances are she's run into some of that Washington, D.C. traffic. What do you think? Yeah? Okay, yeah, I think that's what we got here. And, but the National Bar Association is a natural partner with the law school on the symposium and any number of other things. So Wiley Branton was, looking at the family, a founder, one of the, I know he was very active in the National Bar Association, I'll say that. I know he was very active in the NBA. As I hope many of you will be, you can be as students, I'll just do the little plug for her, as students, as law students, but certainly as lawyers, that you will become members of the National Bar Association. It's a very fine organization, and it has its impact, again, great partner with a lot of groups working on social justice issues and great support for folks in terms of their careers. So I bring greetings then, I know in her place, President Rosier, for the National Bar Association. You know, I just recall that the National Bar Association also has a Wiley Branton Award that they give every year, and I believe they will be giving that award tomorrow, right, at a luncheon. So again, they recognize, and that's another reason why they're partners with us, is that the immense accomplishments of Dean Branton, and this is their way of continuing to carry his legacy forward with their award, recognizing those who are walking in a similar path. Now, I told you at the beginning that the symposium takes a lot of hands, but largely the symposium is managed by members of the Howard Law Journal. When we started the symposium about 10 years ago, that was not the case. It was largely the faculty working with the journal, but we've completely flipped. We work with the students. The faculty, we work with the students. The students are in the lead, and they've done a very fine job. And at the helm of the Howard Law Journal is a third-year student who is a member of the class of 2014, Ms. Erica James, the editor-in-chief of the Howard Law Journal, and she will now bring remarks.
Good morning. Thank you, Dean Dark, and thank you to our sponsors. We're so happy and grateful for your partnership. My name is Erica James, and I serve as the current editor-in-chief of the Howard Law Journal. I know Dean Dark gave recognition to our journal members, but I quickly want to recognize my Branton co-chair, Richard Carlton, who's in the back, the Branton committee members, the Howard Law Journal Executive Board, and all of our staff members. If you could please stand quickly at this time so that we may recognize you. Thank you for all that you do. On behalf of the entire Law Journal and the Branton Symposium Committee, we are delighted to see you and welcome you all to this 10th annual Wiley A. Branton Howard Law Journal Symposium. This year is a special year, and we are happy to partner with the Lawyers Committee for Civil Rights Under the Law as they celebrate 50 years of service. Thank you for your partnership on this journey. I want to begin by telling you a little bit about the Howard Law Journal. Founded in 1955, 1 year after the landmark decision of Brown v. Board of Education, the journal was established at the beginning of an era marked by robust advocacy, the equal rights and civil disobedience designed to secure them. In short, the journal was born at a time when an oppressed people in this society joined together to seek justice, equality, and freedom for all Americans. Consistent with our origin and continuing the mission of the law school, members of the journal dedicate themselves to promoting scholarship focused on the continued advancement of civil and human rights of all people. Entirely student-run, the journal is published in one annual volume, which consists of 3 issues that contain articles, essays, book reviews, authored by legal scholars, as well as notes and comments authored by our journal members. I'm truly honored to stand before you today as we host this 10th annual symposium. For the past 10 years, this symposium has provided a forum for students, practitioners, and academicians to engage in meaningful discussion about the ongoing fight for social justice. This year's theme is truly timely when considering the state of the nation. If our former Dean Branton was here today, I am sure he would agree that we are truly at a critical juncture. No longer Jim Crow race-hate segregation, but Senate and House dysfunction with heavily racial undertones. No longer exists a focus solely on racial discrimination and disparities, but a more broadly encompassing focus. A focus on anti-immigration laws that threaten the liberties of immigrant citizens, a focus on the negative health impacts of unequal environmental treatment, a focus on lesbian and gay rights to marry a partner of their choice. These few examples indeed illustrate that we are at a critical juncture. But not all the issues we face at this juncture are new. Who would have thought that 48 years after the enactment of the Voting Rights Act of 1965, we would still be fighting for an unsuppressed right to vote? Despite decades of progress, it appears as though some of these new conflicts may merely be deceitfully dressed old conflicts in new garb. Be it old or new, the crux of this concern is that we still have work to do. How will we move forward? How will we respond? This symposium, our yearly exercise, is designed to not only provide an opportunity to pause and reflect, but to equip us with the tools to answer these questions. How fitting is it that we sit here on this campus at Howard University, an institution that has never backed down from questioning and confronting issues to ensure that what is being done is just and what is just is done. Like the pioneers of the civil rights era, this new generation, our generation of activists and social engineers, must be ever ready to carry on the torch and continue the fight for justice for all. I challenge you to think critically, pose questions, and help us push forward the life and legacy of Dean Branton. So we hope you enjoy this symposium as we discuss these critical issues. Feel welcome to participate and not only engage by asking questions, but please do follow us on Twitter and use the hashtag that we've provided, as Dean Dark has mentioned, BrantonX. Please also remember that in the foyer, we have complimentary issues of last year's Branton Symposium, which focused on protest and polarization. Also, this afternoon in the foyer, you may also subscribe to our journal. Our first issue will be out by the end of November, so it's a great time for you to subscribe. Finally, the presentations that you hear today and throughout this afternoon will be published in the third issue of this volume, which will be published in the spring. Again, we welcome you to our 10th annual symposium, Civil Rights at a Critical Juncture, Confronting Old Challenges and New Conflicts. We truly hope you enjoy. Thank you.
Okay, at this point, you're going to observe it, but we're going to do a little segue to the next session. And so I will thank you very much. As our next presenter comes forward, the Lawyers Committee for Civil Rights Under the Law is celebrating its 50th anniversary, and you will be hearing from the President and Executive Director, Barbara Arnwine, in just a moment. The Lawyers Committee for Civil Rights is another institution that does not back down. Whether it is housing discrimination, voting rights, employment practices, affirmative action challenges, you will find the Lawyers Committee there. And they are there, they are well prepared, and they are ready to fight, and fight successfully. I tell you, there are so many ways in which the Lawyers Committee and Howard Law School over years have partnered and worked together. I mean, they're just innumerable ways. So it, again, makes sense that they would be a co-sponsor of this symposium. Barbara Arnwine has an extensive bio That is way, I mean, it's extremely impressive. I'm just going to say, all you have to do is Google or look in our program, and let me tell you, it is stellar. What I know, she is a true sister in the struggle, truly committed to making sure that we have an open, fair, inclusive society that provides equal opportunity for all. We are very fortunate and blessed to have the Lawyers Committee as co-sponsors, but especially because at their helm is Barbara.
Good morning, everyone. Good morning. What an honor it is to be here to participate in this 10th annual Wiley A. Branton and Howard Law Journal Symposium. I would like to open by extending my deepest appreciation to the Howard University School of Law and the National Bar Association for co-sponsoring this critical symposium, along with those amazing law firms of Sidley in Austin and Debevoise in Plimpton, two of our leading law firms for the Lawyers Committee. I want to extend many thanks to Dean O'Keefe Dark, who has been amazing in this process and in so many other work that we've done together, and also, of course, to the National Bar Association's president, Pat Rozier, who has been wonderful, and we have some new programs that the Lawyers Committee and the National Bar and the NAACP will be rolling out on here in DC and in Maryland on expungement and working on those issues. And I'm hoping that many of you will volunteer, because we will be having both lawyers and law students involved and engaged in that program. We also want to thank everyone at the Lawyers Committee who has helped to make this possible. And I will come back to that. But I want to also say that it has been my pleasure working with some who have already graduated, but many who are still here, the members of and the students of the Howard University Law School Law Journal. You have been amazing, wonderful, brilliant. Erica, thank you for your leadership. Your remarks were excellent and inspiring, and I am so happy that we've been able to plan this. Now is its 50th year. The Lawyers Committee is continuing to move America toward justice by fighting against suppressive voting laws, discriminatory lending and housing practices, racially predatory commercial practices, employment discrimination, our very, very, very unjust criminal justice system, so-called. We're dealing with the unfairness and the wrongs that we see daily in immigrant rights, the deportations that are excessive and unnecessary, and dealing with the unequal educational system that pervades in our country. So these are issues that aren't issues of the past, they are our current realities. And they demand that we are engaged forcefully in combating them and creating the new America that must come into fruition. It is absolutely gorgeous to be here to follow in the legacy of Wiley A. Branton. He was one of our founders, and he was a man who I had the privilege of working with for just a very short time, but all the impression he made. I want you to know that every time Wiley Branton would speak, he would reach into his pocket and pull out what he called the honor roll. And the honor roll, family knows what I'm talking about. The honor roll was a list of all the African-American attorneys who worked, told, sometimes at tremendous personal sacrifice, to wage the civil rights battle when no one else would stand, who may have been the only attorney in their area, the only attorney who would take a civil rights case, who were jailed. As you will hear, spend some time today, talk with John Britton and hear the stories of what it was like to practice in Mississippi in the late 60s and the early 70s. Hear about being jailed by judges because you dared use the terms racial discrimination. These were the lawyers that he would read their names. He wanted us to make sure we never forgot who they were. And his powerful exhortation to honor this legacy will always live with me. It is my greatest, honor, my real privilege to have known him and to have worked with him carefully. We know that nothing is more important than the pursuit of equality in higher education and how key it is to the quest for racial justice. I want everyone to know that all day today you're going to be confronted with amazing panelists. I am so happy that many of those panelists will be drawn from the staff of the Lawyers Committee. I'm also happy that so many people who have been involved in the Lawyers Committee will be on that. But there is one person who I want to really make sure that we recognize today, because this is part 2 of our legal symposiums. We had a part 1 on June 20th at the Georgetown Law School that was very well attended, really an all-day, very intensive examination of civil rights. But none of that would have happened without the guidance, the instruction, and the help of our board member and chair of our board committee, Paulette Caldwell of the New York University School of Law. Thank you, Paulette. And a graduate of Howard Law. Absolutely. Thank you so much for your leadership. In addition, I wanted to also thank the members of our board who have traveled here, some from California, some from New Jersey. Well, all the board members of the Lawyers Committee who are present, I know there are a few of you who have been able to break away from trials and other great duties to be here with us. Can you please stand and be recognized? Thank you so much, members of the board of the Lawyers Committee. Thank you. The daily work of the Lawyers Committee is done by our staff. Our staff is amazing. They work hard, they sacrifice, they work evenings, mornings, weekends, when necessary to make sure that equal rights is a reality as much as we can in this country. And I would like to have standing all of our amazing staff. I want to give special recognition to Karen Miller, who came in and has led our 50th anniversary planning. She's been awesome. I want to give recognition to Stacy Royster, our Director of Communications, who has done a fantastic job of making this happen, and Laura Hunt, who has helped me plan for this first panel. Thank you, Laura, as a law intern. But will all the staff, the amazing staff of the Lawyers Committee, please stand and be recognized. Absolutely. You see a lot of young faces because many people upon graduation have fought for those fellowships and have become members of the Lawyers Committee staff in that regard, and others have been hired to do this important work. I really encourage everyone to think about how you spend your summers, think about how you're going to spend your career, but always be focused on the criticality of using your incredible talents to promote and fight for racial justice. But I am here also at a special time, because earlier this month, with the ongoing persistence of the Howard University Law School Clinic, we received a tremendous victory in the state, in our HBCU case against the state of Maryland, on October 7th, federal judge Catherine Blake ruled that Maryland violated the Constitution of the United States by unnecessarily duplicating their programs that were at HBCUs by putting the same programs, loading more money into those programs at predominantly white institutions. This case, this very important case, opens the floodgates for more litigation throughout the country to make sure that HBCUs, historically black colleges and universities, have the resources, have the equal treatment, are not run out of existence by unthinking and sometimes purposefully wrong governments. I want to give a big shout out, not only to all the members of the Law Clinic who worked on this, but also to the law firm of Kirkland & Ellis. As you know, the way the Lawyers Committee works is that although we have a staff, every single case we do, all the research we do, all the public policy advocacy we do in Congress and in the states, all of the mobilization that we do through election protection, all of that is done in conjunction with the major law firms of this country, that they give us their resources. Indeed, in 2012, the annual budget of the Lawyers Committee, that is the actual money that we raise every year, is about $8.3 million, but because of the donated pro bono legal services of the law firms, our operational budget was $47 million. That is the value. Oh, yes.
Good reaction. That's good.
That is the value of donated pro bono from the law firms. So that is who we are, and that's to understand us clearly in perspective. This decision was made possible because the hardworking lawyers at Kirkland & Ellis, they donated and devoted themselves to winning this case, carefully examining the law, fighting against some powerful lawyers on the other side, fighting against the public relations machinery of the state of Maryland, fighting against what had been all kinds of intimidation and other kinds of pressure on the black college presidents. All of these problems, we fought and we won because we fought. But I also want to say that one person who made a big difference in making this case happen was not only John Britton, who you will hear from later on today, but also our incredible chief counsel, John Greenbaum. Where are you, John? Stand and be recognized, because you did a marvelous job. This case will ultimately benefit so many others, and we hope it will create this ripple effect throughout the country. As the title of our symposium suggests, civil rights is now at a critical juncture where we both celebrate our many successes and look to the future as we address the state of racial justice in America. Nothing is more important than our discussion about the use of affirmative action. It really exemplifies the critical junction. The Supreme Court of the United States is now in the process of considering the Suet case, whether it's constitutional to eliminate affirmative action in public universities via referendum. This decision could drastically change the way states engage in affirmative action. And last term's Fisher case, with its mixed results, left a whole lot to be desired. But as we see these decisions and this jurisprudence evolve in the United States, we must recognize that we have to start exploring newer and more innovative solutions to achieve equality. To do this, we can't just look at the United States, because what we miss being in the U.S., because we're so isolationist in our jurisprudence is how much work is being done around civil rights and racial justice and ethnic justice and gender justice and all kinds of other issues in other nations. We miss the progressive framework that is evolving, almost revolutionary framework that's evolving throughout the globe. And an international comparative approach broadens its perspectives on the obstacles that we face in reaching our goal of racial equality and increases the number of solutions. In fact, I would argue that it is possible, it is impossible, to be a modern-day civil rights attorney and not have an international perspective, to not understand the incredible thinking, solutions, barrier-breaking theories that are evolving all over this world. It is important for us to understand how to export and how to import the best ideas. So, in the panel that will follow, we'll be discussing affirmative action policies and their effect in Latin America, throughout the, as I call it, the Americas, even reaching up and grabbing some Canadian analysis, and what the United States can take from that substance and spirit of these programs. At this time, I would like all our panelists to come forward so that we can get underway quickly. As they come forward. Excellent, excellent. As they come forward, I want to tell you a couple of things real quickly. Okay. Oh, class. Yes, okay. Yes. Oh, they must have a class coming up. People are running out. Oh, wow. Okay. All right. Okay, great. Those are the ones that said. Okay. All right, good morning. Good morning, Lisa. Good morning, Gail. How are you? Questions? Yes. Okay. Gotcha. Gotcha. Okay. All right. It is a school day. We understand that, and that people have to graduate, and that's the most important thing. Our panel today is entitled Alternative Universes, a look at affirmative action in the Americas as part of the 10th annual Wiley A. Brannon Howard Law Journal Symposium. I am happy to introduce to you a superb panel of the globe's foremost experts in the subject of affirmative action. What a blessing. Our first panelist today is going to be Tanya K. Hernandez, who is a professor of law at Fordham University, where she teaches several courses, including critical race theory and comparative employment discrimination. The full bios of all panelists are in your materials. Please consult them. I want to get into this discussion. We only got a little bit of time, so I am going to not go into the amazing in-depth bios of all our panelists. We are also fortunate to have with us Kimberly Williams Crenshaw, who is a professor of law at Columbia and UCLA law schools, where she teaches many courses, including critical race theory and civil rights law. I'm also happy to introduce your own professor, Lisa Crooms Robinson. She is the Associate Dean for Academic Affairs and Professor of Law at Howard University Law School. She teaches several courses, including International Human Rights and Gender in the Law. These three amazing panelists have traveled the world, have interacted with scholars across the spectrum on these issues, have written extensively, and are amazing. And it's an all-women's panel. I'm sorry I tried my brothers, but it just didn't work. I tried. I chased them all over the globe. And I just couldn't succeed in making it work, but I tried. I want everyone to, receive and welcome this incredible panel. All right, so I'm told to tell the panelists to please speak directly into the mics for the recording, for the purposes of the recording. And our first person that I'm going to turn to is Tanya Hernandez. And to Professor Hernandez, can you give us a brief description of some of the affirmative action programs that are established or are currently being established in Latin America?
Certainly, and thank you very much. It's a great pleasure to be here with you all. Can I be heard all the way in the back of the room? Lovely, okay. So first I would say that I would concede that affirmative action programs are emerging and are not completely in every single country in Latin America, but what is noteworthy is the great activity that is being generated in the few countries that have turned their attention to race-based affirmative action. And here I want to be very specific because Latin America has long had programs of gender-based affirmative action without much controversy. We can talk more about that later if you choose. But race-based affirmative action has been a more taboo subject, and so it's quite interesting to see what the countries who have turned their minds to it have done with it. So to be very clear, the countries that have been doing work on this have been Brazil, Colombia, Ecuador, Honduras, and Uruguay, interestingly enough. So it's a sort of a wide spectrum of countries, both North, South, and Central America. The variety of affirmative action programs are evident in university educational settings, in public sector hiring, with civil service examinations. Certain number of points are accorded additional for persons of African ancestry and also indigenous ancestry. In Ecuador, there's even sort of set-aside programs for the construction of low-income housing specific for Afro-descendants. And in addition, people who contract with the public government also have to have particular set-asides. And here I also want to make note that in Latin America, the race-based affirmative action programs sort of harken back to much earlier versions of the United States in the sense that they are outright quotas. They're numerical, so they're nice and clear. There's a way to confirm whether or not the goals are being met. And so in that sense, it is different from what you see today. And then I guess the last thing I'll say is just as far as the spectrum of what is available in Latin America as far as affirmative action programs based on race is that just this past August, so it's very new, Uruguay implemented a brand new statute that is in some respects one of the most comprehensive in the region, because not only does it set aside specific targeted number for university slots for people of African descent. It also includes public sector hiring goals. It also includes, and here's where it's particularly interesting, a tax incentive for private employers to hire Afro-descendants, and in addition to mandating that courses on the history of Afro-Uruguayans be taught across the educational levels. So quite a bit of variety, but interesting activity.
And that's fascinating when you consider that the state of Arizona is banning, is banning the teaching of Chicano studies and Latino studies. So that's fascinating. Once again, the alternative universes, right? Can you tell us, Professor Hernandez, are you seeing a particular trend towards a certain type of affirmative action program in the region?
I would say that there is a clear pattern, that while there's this variety that I've described to you, the predominant number of programs are in the educational setting. And I believe that's for two primary reasons, and I should say in the university level of the educational setting. And I think the reason for that is because, unlike in the United States, in Latin America, the framework is that the university, usually typically the most elite universities, are those that are the public universities, sort of our University of Michigan, our UCLA, et cetera, and they are free. They are free. But in order to gain admittance to these free, elite, public universities, one must take a standardized test of admission for these universities. And this is across Latin America. And what had consistently been the pattern, low these last few hundred years, is that they were elite, racially segregated spaces. And so as these countries have become more democratic and have become more concerned with international pressures and social justice movement activity and lobbying, so they've been more influenced by the concerns with appearing to be racially segregating their population. The federal government has had the most influence to bear on the university setting. And of course, it also stands to reason that the university setting is the place in which one can gain most traction as far as upward mobility across race, because you're providing people with the actual tools and networking that facilitates that upward mobility.
My goodness, free university? That's a concept we would like to see in the U.S., like right now. Professor Hernandez, using Brazil as an example, what have been the effects of the affirmative action programs on its society and economy?
Well, what's been very interesting is that because Brazil has had the longest amount of experience in Latin America, that is, with race-based affirmative action in the university setting, they've also had the ability to track their students and see what their performance has been. And what they have discovered, what the empirical data shows, that much to the chagrin of those who critiqued the implementation of race-based affirmative action, the affirmative action students, or as they're known in Brazil as cochistas, the quota students, the cochistas have been doing quite well, thank you very much. And indeed, they have in a fair number of the areas of study have been superseding their non-cochista counterparts. And the social scientists that have been researching this trace this to the educational resiliency of these young people who sort of, have to fight their way in, have to study really, buckle down really hard in order to deal with those entrance examinations that oftentimes test on subjects that these students have not even been taught properly in their public secondary schools. Because here's a little trick to this free public university. The test is so rigorous that white elite parents send their children to private elementary and secondary school and pay for courses, sort of like in your LSAT prep score course equivalent, for years at a time, in order to gear them up to be able to get into these public free universities. And so the educational resiliencies of these cochista students to sort of find their way in there has accounted for their great success.
Amazing. Is there a reason why affirmative action programs are not as prevalent in Central America?
Well, I mean, I would trace this to some of this being pragmatic, the demographic differences. So in Latin America, people of African descent can, in some places, be almost a majority, as in Brazil, or close to a majority, as in Colombia. The census plays some funny business with the numbers, yes. So I can't be exact, yes, with you. But in places like Uruguay, for instance, they are much fewer in number. Argentina, even fewer in number, though they're there. We're everywhere. And so I think that in the places in the country, the regions in Latin America that have fewer numbers, it's been harder for them to gain the momentum, right, because they don't have the numbers. In addition, in places where there hasn't been an indigenous movement, like Colombia, had either simultaneous or preceded the traction of the Afro-descendant movements, the indigenous movements sort of laid the groundwork in some respects for, in Spanish we say ablandando, sort of softening the ground so that government actors would be more receptive to the claims based on race. And then the last thing I would say that may account for some of this differences, where you see more resistance as opposed to less resistance, is that where the people of African descent are fewer in number, they also have more difficulty working against the pre-existing race ideology in Latin America, which has been traditionally different from the United States, although is sounding more like where the United States is going, and that is the notion that in Latin America we have no racism because we are all mixed, and so you can't tell anybody apart, and so there's really no racism, there's really no black and there's no white, we're all just one big happy mix. And of course what that completely overlooks is the extent to which one can find race disparity across the society, deeply entrenched across the socioeconomic spectrum, that is attributed to more than just a class differential. And so where we're seeing more resistance to race-based affirmative action, it's often because these people who are fewer in number who have to even fight harder against this racial democracy mythology that exists in Latin America.
That's powerful. Thank you very much. I'm going to turn now to Professor Kimberly Williams Crenshaw. Professor Crenshaw, what have been your observations about the unusual trajectory of affirmative action over the course of your many, many visits to Brazil, where you've been a special Fulbright scholar? Why don't you give us that perspective?
Okay. Good morning. First of all, thank you for inviting me. And Barbara, it's a special pleasure to be in this conversation. Yes. Barbara and I go back to, well, actually longer than that, but our Brazil connection was in 1999 when we were invited by a group of Afro-Brazilian lawyers to come and talk about possible strategies for dealing with racial stratification in Brazil. What kind of lessons excuse me, could we share with them? And we were struck by two things. First of all, we were struck by how deep and penetrating the stratification was there. We were struck by the very images of the favelas. We were struck by the degree of racial marginalization, which in many ways paralleled what Mississippi might have looked like in 1945. The differential opportunity structures was so stark. And the second thing we were struck by was our colleague sharing with us the idea that this stratification, as deep and as structured as it was not amenable to any kind of racial framing. That by and large in Brazil, the myth, as Tanya just mentioned, of racial democracy took the possibility of addressing this deep stratification as a racial problem utterly off of the table. So one of the challenges that they were facing was how to deal with a material reality when the prevailing ideology didn't permit that reality to be named as a racial problem. And so we began with some conversations about the few legal opportunities that existed, and one of the main approaches, and frankly the only approach, was to have a criminal statute that allowed for some prosecution for certain kinds of individual acts of race discrimination. But those were notoriously hard to prove. It's more or less like taking Washington versus Davis and putting it into a criminal statute and thinking that you were going to get some traction on dealing with structural, institutional, and cultural forms of racial discrimination. So that was not possible. And then we moved to talking about affirmative action, and that seemed like utterly in another universe, to pick up one of the themes. That the idea was that because Brazil had never formally used racial classifications, did not formally have anti-miscegenation statutes, did not formally have segregation. Notice these are the main ways in which U.S. racial stratification is framed. Because they did not have those kinds of state-embodied forms of discrimination, affirmative action was seen as being tied exclusively to those kinds of discriminations. And since Brazil did not have it, then affirmative action was not on the agenda, however much they might have hoped that was likely to be the case. That was in 1999.
Amazing.
In 2005, and I'm just using that as an endpoint, Brazil has one of the most aggressive forms of affirmative action that one can think of, as Tanya mentioned. It's not a thumb on the scale. It's not a diversity approach. It is actually quotas. And so the question is, what happened between 1999 and mid-2000, 2005 that brought that about? And quite frankly, one of the most significant things was the World Conference on Racism.
Right.
The World Conference on Racism brought Brazilians into the international discourse on race discrimination in a big way. By that, I mean the Brazilian contingent was the largest one, and the largest one of Afro-descendants in the World Conference process over a period of 2 years. Brazil was one of the leading forces in the process to insist upon including in the document and in the platform of action recognition of the fact that race-conscious remediation should not be subject to the same kind of frameworks that racial discrimination was. In other words, the distinction between race discrimination and affirmative action that we've been fighting about for the last 50 years here is deeply embedded in the international documents. Because of that, and because of Brazil's leadership in the international arena, once folks got back into Brazil after the World Conference on Racism, there was much more receptivity, first of all, on the part of the Lula government, and then shockingly, surprisingly, on the part of the Brazilian Supreme Court, to the idea that substantive equality, to the idea that there are specific social responsibilities that the state actually faces to penetrate into the social arena and to address forms of discrimination that trump the idea of formal equality. That idea is now embedded in the discourse around race in Brazil. So I would say the most significant thing was the international community, which activists then took the opportunity to utilize as discursive and political tools in the Brazilian social terrain, and that in turn led to a foundational transformation in the way race was thought about, and that became the predicate for permitting affirmative action.
Fabulous. Do you think that the difference between the way North America views race as compared to Central and South America affects the way that affirmative action programs have been debated and rationalized?
Absolutely. Well, again, building on what Tanya was talking about, there is a myth of racial democracy, and if we might sort of line them up, we have our own myths here. Color blindness, for example, which we've seen start as a attempt to move from the progressive side of the discourse, an idea that was articulated by Martin Luther King in a particular context, to then apply across the board to all race-conscious measures. I think the most significant aspect of that is in the PICS, Parents Involved case, where colorblindness arises out of Justice Roberts' opinion as the main constitutional injury that Linda Brown suffered. Namely, it wasn't that she was sent to an inferior or subordinate school, but because the state used race as a classification. So she was harmed in the same way as the little white kids that she was walking by on the way to her inferior school. That's a moment of using colorblindness to do a certain kind of racial erasure. Brazil has its own version of it, and it's called racial democracy. It's not technically colorblind in the sense that it erases all history around race. In fact, it does the opposite. It tries to argue that because Brazil is such a mixed race society in the way that Tanya mentioned, in fact, there is actually policy around immigration to encourage European immigration in order to handle the race problem. And that handling of the race problem was an absorption, or at least that was the theory. So if we basically bring in a whole new genetic pool, eventually the problem of separate races will do away with itself because that genetic pool will absorb the African presence in Brazil. This is framed as a liberal policy. It's framed as a non-racial policy. It's framed as racial democracy. So note that Brazil has its own contradictions. A race-specific justification for immigration, and at the same time the use of free and open miscegenation as a sort of polar opposite from the United States. So racial democracy circulated as this idea that we're different from the United States because we have miscegenation. Consequently, our miscegenation means that we're not a racially stratified society. Now, the reality is, and many Brazilian activists have pointed out, this is just a technique or a tool for racial subordination. So people have different tools. We say tomato, they say tomato, but basically the project is a white supremacist one. Right. So the argument that they never had racial classifications is the main argument that's used against affirmative action there. And consequently, it gets framed like, we can't import this predator or this pest from the U.S. because it will disrupt our delicate flora and fauna in the Brazilian context. So that's a particular kind of argument that is quite distinct here, and it's created a pushback. The pushback is, just because we didn't have racial segregation, and just because we didn't have miscegenation laws doesn't mean we didn't have our own scope of state-sponsored policies that have created this racial hierarchy. Immigration is one, who gets access to land is another, the role of the police is yet a third. So everyone has their own particular landscape of racial stratification, and Brazil is now about the process of being cajoled, forced, welcome into interrogating those.
You know, I mean, I'm struck by, you know, how much racial denial, how the role of racial denial in the U.S., in Brazil, because, you know, people forget that in Brazil in the 1930s, 40s, that when the junta took over, that they actually murdered all the black activists. Because this is not the first time there's been an Afro-descendant, you know, fight in Brazil. And that that's why there was such a, you know, void for so many, you know, decades. Was, you know, the imprisonment, the outright murder, eradication of that movement. You know, and also, you know, I'm also struck that in Brazil they actually have a term, I just can't recall it, that means honorary white. That if you, in fact, become a black lawyer, or you become a black doctor, and you are visibly, phenotypically black, that you become what's called honorary white. Yet, all of this is layered on top of this mythology. Can you tell us what lessons, if any, can be drawn from the Brazilian Supreme Court's endorsement of the endorsement of affirmative action and the U.S. Supreme Court's narrowing permissibility of race-conscious measures as we see attempted in Fisher?
Well, so building on the comments that you just made, so the Supreme Court unanimously upheld a quite ambitious affirmative action program. Tanya also gave some of the contours of it against a typical kind of challenge that these quotas represent reverse discrimination. There's not one opinion, there's several, and they're in Portuguese, so you have to trust me and my bad Portuguese in interpreting some of them. But one of the interesting differences between, I think, the Brazilian jurisprudence on race and the U.S. Is that while in Fisher, and Fisher is just the end of a long process of the court engaging in what I would call naturalizing racial hierarchy. Basically, we don't know why there's so many disparities still in access to higher education or any other of our professions. We're just going to assume that it has nothing to do with discrimination unless it can be proved by a very high standard, namely Washington versus Davis. So any other kind of racial disparity is just there. And colleges and universities and states don't have any particular role or responsibility in addressing those disparities. First of all, they ruled that they don't have to, and then most recently they've ruled that even if colleges, universities, and states want to address racial disparities, that they're doing so outside of their role and potentially engaging in reverse discrimination, which is now why the standard is now so high. But that relies on the ability to distinguish between what kinds of arrangements the state is responsible for and which kinds they're not. So race is now a free market thing. You got what you got, and it has nothing to do with anything historical or anything that the state can do anything about. Brazil took a completely different approach to that, and what was really interesting is it broke down the idea that stratification and other inequalities in society are just there and the state has nothing to do with it. And explicitly, the court said that it's the state's duty to penetrate in the world of social relations and correct distortions so that the equality that's guaranteed regains its beneficial role. So in other words, formal equality is not enough. The state's taking a hands-off position is not enough. And instead, the idea that Brazil is a society in need of repair, and repair will be the broad way in which these programs will be viewed. Of course, they have to be proportionate, they have to be reasonable. All the stuff that we used to have in our equal protection doctrine is there to modify and rationalize the repair. But the broader idea that this is about repairing, it's the idea that Martin Luther King talked about when he came to the March on Washington. We don't talk about that part of the speech. Right. But when he talks about we're coming to cash a promissory note, we're coming to put a society that's in disrepair in repair, that's a broad ideological framework that we've largely repudiated, and Brazil has lifted it up. So it's sort of like we're like two ships passing in the night, right? Brazil's coming from this period of historical denial all the way into racial democracy, and it's slowly shedding that. And we're moving in the direction that they came in, into a more formal denial about our racial history.
Fascinating. Can you tell us what lessons can be learned from recent attempts by the Obama administration to create bilateral partnerships to address racial exclusion? The JPER, for example, the Joint Action Plan on the Elimination of Racial Discrimination comes most readily to mind since we were in Brazil a year ago this time, discussing that compact.
On precisely that issue. So the Joint Action Plan for the Elimination of Racial Discrimination is otherwise known as the JPER. I'm curious, how many people here have heard of that, JPER? Okay, so that's part of the problem, right?
That is the problem.
So we would think that if there really was a joint action plan on the elimination of racial discrimination, at least folks who would be attracted to and participating in this conversation would know all about it. And we don't. That tells us something about, I think, what the limitations of that particular joint project is. So quick history. So some of you might remember that when the president of Brazil visited with our former president embarrassed us when he said something to the effect of, "Oh, you have blacks there too." There are more people of African descent in Brazil than any place outside of Africa. It is a deeply Africanized country, and our president didn't know anything about it. It could be because of that his administration under Condoleezza Rice entered into a joint agreement with Brazil to address our common racial history and some of our common challenges by sharing best practices and working together to develop more egalitarian measures for integrating people of African descent into the various societies. So this was a State Department project that was meant to partner with government agencies there and basically bring in all of the insight and expertise that both countries had to offer to solving this problem. The problem with that problem solution approach is that it was a State Department project. It was basically located in diplomacy, in negotiation, in figuring out ways that we can play nice with each other in a particular arena, and not necessarily how to bring all resources to bear to problem solve. So if we're just going to compare, we have joint action on energy, on weaponry, on patents. Those joint action arrangements bring everyone to the table who has something of interest and some expertise. So people in the broader industry come to the table, researchers come to the table. One doesn't think that a State Department official actually knows the chemical makeup of the newest energy source. But when it comes to this, many of the experts, again, I asked how many people heard about this, weren't brought into the conversation, and it was instead a conversation that was basically pursued by government bureaucrats. I have nothing against government bureaucrats, but the expertise that's necessary from the activist community, from the research community, that we would otherwise think is important in this conversation if it was really taken seriously, was just not part of that conversation. So consequently, we've got some great sound bites. We've got a lot of intentionality, a lot of feel-good, sort of speeches. What we haven't been able to do yet in JAPER is really bring to bear all of the expertise that we have about how to build an affirmative action program that works, how to frame racial justice in a way that brings other people on board, how to make sure that quotistas will have job opportunities when they get out, and for us to learn how to maintain racial justice in the face of a societal-wide denial that wants to frame our racial problems as not the problems that we, the state, have to solve, but simply problems that individuals and groups have to solve on their own.
Thank you. Thank you so much. Professor Crooms Robinson, how does the use of affirmative action fit into the struggle for human rights internationally, specifically to the goal of ending racial discrimination?
Good morning.
Good morning.
Good morning.
Good morning.
Good morning. Thanks to the Branton folks. Thanks to Barbara and my co-panelists. Two people I haven't seen in such a long time. It feels like old home week or old home day. Okay, so the use of affirmative action fitting into the struggle for human rights internationally, and considering the goal of ending racial discrimination. I'm going to do the same thing as Professor Crenshaw, although this might turn out differently. How many of you all have ever heard of the International Convention on the Elimination of All Forms of Racial Discrimination?
Much better.
Oh, that's much better. Okay. And I dare say, actually, probably 10 years ago, it would have been fewer people. Okay, so I raised that particular convention, which I will call CERD, because CERD includes two provisions that address what the convention refers to as special measures, but they are among the special measures that they're talking about would be race-based affirmative action, the sort of race-based affirmative action we would be most familiar with. So, first, what CERD does is it explicitly excludes these special measures from the definition of racial discrimination. So they see, the treaty itself sees these kinds of measures as being necessary in order to ensure groups or individuals' equal enjoyment or exercise of human rights and fundamental freedoms. So, provided that you meet some other requirements, that is, you don't set up a dual system, so you've got different rights available for different racial groups, and you do not continue the particular measures after the overall objective has been achieved, the convention permits the very kind of race-based affirmative action that has proved to be so problematic, particularly the last half of the 20th century as far as our own Supreme Court is concerned. The second provision with respect to special measures under CERD imposes upon a state a duty to take, and it says, in the social, economic, cultural, and other fields, special and concrete measures to ensure the adequate development and protection of certain racial groups or individuals belonging to them for the purpose of guaranteeing them the full and equal enjoyment of human rights and fundamental freedoms. So what does that mean? That means that if, for example, you have the kind of data that both Professors Hernandez and Crenshaw have referenced, particularly in the context of Brazil, that in and of itself gives rise to a government duty, not only to, in fact, investigate why that disparity exists, but actually to address the disparity. And one of the ways that you can, in fact, address the disparity is to adopt, implement, and enforce what we would call race-based affirmative action programs. That's where the international law of human rights is. Now, why am I talking about this in the context of this conversation? In part because the countries that have already been discussed, they're signatories to this particular treaty. But more importantly, in some ways, as far as I'm concerned, we are too, we being the United States, which means that this puts the United States at odds with treaty norms that are included in treaties that we have in fact signed and ratified. Now, if you want to get into the particulars of how that is possible, I encourage you to take international human rights law, currently taught by Professor Steve Jamar if you were a student here. It's much too complicated and quite honestly much too dry to in fact raise now, but let's just say it involves something called reservations, understandings, and declarations. We're right? See, you hear the groans. We're not going to go there. Okay, so as it relates to these two particular provisions, there's a committee charged with monitoring compliance with this particular treaty. And in 2009, that committee adopted what's called a general recommendation. And general recommendations provide you with definitions. It gives you guidance with respect to how the rights articulated in a particular treaty may in fact be realized. The purpose of this particular general recommendation was to provide practical guidance on the meaning of special measures under the Race Convention, to assist, let's hope, the states to discharge their obligations under the convention. One of the interesting places, or one of the interesting points of guidance here, is the requirement or the call for what they call a context-sensitive interpretation of the treaty, meaning while the rights are in fact universal, how that plays out depends entirely on the particular circumstances of the state party that you're talking about. So what special measures look like in the United States, for example, will be different from what special measures might look like in Brazil, what they might look like in Ghana, what they might look like in South Africa, what they might look like in Jamaica. This, for those of you all who have had Con Law 2 at the very least, this, I think, ties into what Professor Crenshaw has talked about in terms of racial erasure. But it's racial erasure in the context of the United States, where you look at cases starting with, let's say, Croson, and moving forward, that strip the Reconstruction Amendments of the racial particularities of those amendments, thereby assisting in this shift from what was a very racialized context. If you go back to, let's say, either the slaughterhouse cases or civil rights cases, at that point in time, the court was clear, and some might contend even too narrow, in interpreting the 13th, 14th, and 15th Amendments in a way that was designed specifically to deal with Afro-descendants. Let's be clear. 100+ years later, we're dealing with a court that requires cognizable claims to, in fact, be stripped of that racial particularity, and instead uses the language of colorblindness. That's how you get to one of my favorites, reverse racism, which I have to say, I spent a little time with the general recommendation, and for those of you all who have Latin in your background, the committee calls positive discrimination or reverse racism as contradictio in terminis. In other words, it's a combination of words that are in conflict with each other. It's oxymoronic, right? But you get there if, in fact, you're able to strip the particularities of both the injuries and the remedies provided in this context by the Constitution, if you strip them of the thing that gave rise to them. So you can talk about, at this point, the 14th Amendment and never mention slavery. What is it? Contradictio in terminis. Oxymoronic, a combination of words in conflict with each other. Now, permissible special measures include they're appropriate to the situation to be remedied, they have to be legitimate, necessary in a democratic society, fair and proportional, and temporary. And as we noted, all you need, really, at least to get the ball rolling, is a statistical disparity. Let the numbers speak. And if you've got the statistical disparity, that then triggers the state's duty to, at the very least, figure out what's going on. Figuring out what's going on doesn't mean saying, well, there's probably a reason why the Afro-descendants are overrepresented among those who are, for example, incarcerated, because the previous administration, this goes back to a trip to Geneva, sat in front of the committee charged with monitoring compliance under this treaty and said, well, the reason why there are a bunch of black and brown people in jail is the black and brown people are the ones who are most likely to commit crime. Enough said, we're done. The committee didn't necessarily buy that particular explanation, but the administration felt that they had, in fact, explained away the disparity. Under the convention, however, that would be insufficient. So I think that begins to answer your question.
Oh, yes. I think so. Our affirmative action plans, such as those found in the Americas, effective tools in ending gender discrimination internationally?
Well, you know, as Professor Hernandez pointed out, the notion of gender equality has had a longer tradition, and in some ways it's been much less controversial, not to say that it's been smooth sailing, right, but much less controversial than the notion of affirmative action based on race. I want to step back and look at, for example, some of the evolution that's occurred in at the international level to back into perhaps the answer to the question. You got these two conventions. One deals with racial discrimination, one deals with discrimination against women at the international level. Both of them permit special measures or affirmative action. Under the Women's Convention, special measures can be adopted to ensure the fundamental freedoms and basic human rights of women, and that they are enjoyed without being compromised. The primary model, at least at the time that CEDAW was drafted, was you were talking women's equality vis-a-vis men, which meant that while you saw some improvement. What didn't happen was the unseating of maleness as the norm. Right? So
Yes.
the fully self-actualized individual actor in human rights law continued to be male. And women were sort of on the margins. Well, thanks to a fair amount of work that's been done by international women's human rights activists, we begin to see a more textured understanding of women's rights. So it's not merely about women's equality vis-a-vis men, which would be intergender, but it's also about digging into and finding intra-gender differences and seeing that as properly part of the conversation about women's human rights. So if you begin to look intra-gender, meaning within the group of women, you begin to see differences that aren't necessarily gender-based in the way that we're used to talking about it, but in fact affect a group of women in large part because they stand outside of the norm. Here the norm would be, depending on the country that you're talking about, we'll talk about the United States, for the sake of making the example easy, that would be white heterosexual women with money, right? If women's equality requires not just equality of women vis-a-vis men, but equality within the group of women, it means that we can have a race, gender, class, sexual orientation. We can have a conversation about discrimination and injustice that takes into account the entire individual. So, the Women's Convention allows you to do that. Similarly, the Race Convention, thanks to another general recommendation, requires states to, in fact, consider how racial discrimination is, in fact, experienced differently by men than it may, in fact, be experienced by women. So it opens up the conversation about race to include, let's say, I don't know, the overwhelming representation of women of color among those who may have, in fact, been subject to sterilization abuse. Right? That then no longer sits as a women's issue. It's an issue that impacts women, in this case, impacts disproportionately women of color, which means, for the sake of the example, it's an issue for the racial discourse, it's an issue for the gender discourse. And the Race Convention has been interpreted so that you don't, if you think about it as having to go to two different places, you no longer have to go to two different places in order to make your claim. In order to say, in order for me to be a whole individual and human being, these are the things that I need taken care of. This general recommendation allows those places where women experience things in a way that is different from men to be fully put before this particular body that's charged with looking at issues of racial justice and racial discrimination. It's a huge deal. So, in that way, it seems that the special measures called for under both conventions, as well as the subsequent interpretation of those provisions by the treaty bodies in question, in fact allow gender-based affirmative action programs to, in fact, work in the arena of achieving racial justice as well. And there's no longer a requirement that people split themselves up in order to, in fact, advance their claims where the claims are, in fact, quite integrated.
And in the last 2 minutes that I have for this segment, just a question. When we talk about the Americas, it's very common to forget about the Caribbean nations. And what has been their focus right now on addressing, racial inequities and the lingering effects of the, the crime against humanity of slavery?
In 2 minutes.
Yes, unfortunately.
Okay, reparations. And if you start from the position that this is all about remedy, this is all about what does it take to make people whole who have in fact suffered crimes against humanity, suffered absolute trauma, beginning with, let's say, slavery and the slave trade, goes through colonialism and manifests itself in neocolonialism, and now we find ourselves in the beginning of the 21st century. In many respects, the discourse around reparations, particularly as advanced by countries on the continent, as well as countries in the Caribbean, that in some ways that is an attempt to get the kind of remediation that is framed as special measures or affirmative action within a particular state. So it's almost as if it's a conversation that looks at who's ultimately responsible for the situation that we find ourselves in. And you see that there's a lot of talk about, let's say, debt forgiveness. Debt forgiveness is part of the reparations movement. Well, in some respects, it seems to me that does, in fact, sort of align, at least theoretically or conceptually, with this call for remediation by way of affirmative action or special measures. There's a troubling piece there, and this is the point that I'll end on. That is, in the Abuja Declaration, which came out of the Organization of African Unity, that is picked up in the Durban Declaration as well, there are some calls, or a basis for a call for monetary compensation for the drain of human capital, particularly from the west coast of Africa, as a result of the slave trade. The reason why I want to flag this is, in some ways, it seems to me it requires the same denial of humanity that slavery was based on in order to get to how do you commodify the lives that you're talking about. And whether the commodification, I mean, it's a conversation, right? Whether the commodification in terms of asking for the reparation rises to kind of the same level as the initial commodification that allowed people to be sold as chattel in standardized commercial transactions. It's the beginning of a conversation, but it's something to consider, and it may be a place where folks might want to step back and say, you want to reframe it. You're not seeking money for people you lost, because to do that is almost to legitimize the original commodification of the people that gave rise to the market.
Excellent. Wow. At this point, we're going to open it up for questions and answers. Now remember, questions. I'm in a room full of lawyers. Questions. Not, not statements of impressions. Before we get to, as you line up, there's mic here, mic there. As you line up for the questions, I want to also recognize a couple of special people who have joined us since we started. The incomparable, amazing force for justice, the wife of Justice Thurgood Marshall, Cecilia Marshall, has joined us. Thank you. Thank you so much. What an honor, what an honor. Deeply honored. Wonderful, wonderful. We are just so grateful to see you. So grateful. Awesome. I also wanted to recognize two members of our board who have joined us. Clarence Donneville, who's one of those lawyers who went to Mississippi as a Mississippi volunteer in the 1960s and had to deal with them justices that I was talking about earlier, who didn't want to hear anybody talking about racial discrimination and was threatening to lock people up and did lock people up repeatedly. Clarence Donneville, one of our award recipients of the Lawyers Committee, and an amazing attorney from Virginia. If you'll please stand and be recognized. Also, I'm very happy to recognize the secretary of our board, a wonderful, amazing advocate for social justice, Ms. Eleanor Smith, who I saw also join us. Thank you, Eleanor. All right, our first question.
Hi.
For our amazing panel.
Hello, my name is Amanda Butler-Jones, and I'm a third-year student here at the law school. My question to the panel relates to some of the comments that you made about post-racial, racial democracy, and whether or not, as we see these emerging policies of affirmative action and what has been described as being aggressive, whether or not it includes any language related to duration or an expectation of sunset, similar to what we saw in the Greta opinion by Justice O'Connor when she talked about there not being a need in 25 years from 2003 here.
What's interesting is that the statutes that are emerging in Latin America that are very specific to race-based affirmative action, the statutes themselves have sunset provisions. So the Uruguay statute that I mentioned that just came out in August is right. It's comprehensive. It has this tax incentive, but it says it's only to last for 15 years, and that every 5 years there'll be a review, an assessment of how well it is moving along. And I think the reason for the every 5-year review is in anticipating at year 15 the need to extend it further, right? Meaning, so there, if you have actual numerical set-asides and they're not being adequately adhered to, then one has data to say, no, 15 years is too soon, or, you know, in a utopian world vision, maybe 15 years is enough to do with hundreds of years of subordination. Who knows? Maybe. But so there's that, and that statute, the Brazil law of social quotas that came out in 2012, that too also has a 10-year period that it's supposed to last. But at the same time, I just point out, you know, there's lots of data gathering happening simultaneously, so I'm not as pessimistic about the sunset actually happening, but it's just one perspective.
So just two points to add to that. One is the contrast that we talked about earlier. So the many gender-based affirmative action programs do not tend to have sunsets. There's an assumption that gender somehow is a permanent feature, or at least resilient enough that nothing will happen within a decade or a generation that will make those irrelevant. What I find interesting about all of them is that they focus the remedy at a particular place, but of course some of the reasons why the disparities exist are far greater than where the remedy is actually happening. So what is supposed to happen right now in the public school system in Brazil, for example, such that in 10 years there's a remote possibility that it won't be necessary? It's the same question that one might have asked, and many did, of Justice O'Connor when she said 25 years. Well, when she said that, the people who were going to be applying in 25 years were already here on this planet. We're already suffering from, you know, under-resourced schools, a whole range of material inequalities, and nothing in the conversation focused on the pipeline. It was all an assumption that in 25 years, suddenly all these people are going to just emerge, kind of like we did when we came, you know, evolved out of the ocean. We just showed up one day. I mean, it's a problematic set of assumptions that is actually one of the commonalities across many of the affirmative action regimes we're talking about.
Thank you. Thank you, Amanda, for your question. Yes.
Hi, my name is Jessica Smith. I'm a 1L here at the law school. Thank you all for coming this morning. My question is related to being women of color in the civil rights movement and knowing that in the history of civil rights that it has been predominantly male-based. And specifically towards affirmative action. Like, how is it, and is there a connection across the, you know, across seas with other women of color being fighters, you know, for the struggle?
Well, I mean, we've been spending a lot of time talking about Brazil, but I think it's because there's been so much activism in Brazil, and in large measure, the activism has been led by women. Afro-Brazilian women. In fact, one of the first places that we saw sort of guides and information about how to use, you know, the limited anti-discrimination law that existed was from Mulheres, was an Afro-based women's organization in São Paulo, Brazil. And so we see that there's that commonality of as far as sort of women are out there, and and then I'll just turn this over to Professor Crenshaw, right? Because it really, I believe, is because it emanates from our intersectional experiences in the world that make it very clear to us how, when you get caught in the crosshairs, you are more particularly vulnerable to societal and structural forces. So I mean, I think that's part of the explanatory power of it. And then in places where that were more less industrialized, like in the northeast of Brazil, the activism came out of organizations of black maids. They came together to deal with their workplace issues, but from that emerged Afro-descended social justice activism writ large.
And the union movement, absolutely.
Well, I'll just build really quickly. I mean, that's a topic for a whole panel.
Oh, yes.
Maybe we'll do that next year. Whole conference, indeed. But Tanya is absolutely right. One of the interesting things in the exchange that we have between Brazil and the United States is the questions that often arise as to why there aren't more women of color-led organizations, you know, both in terms of the head and in terms of the substance. And so, you know, many of our organizations where the women organizations were either auxiliary organizations or help organizations, but the principal organizations were seen as, you know, the male-led organizations, and they're very puzzled and interested in our story. And it does create an opportunity for us to think, why is that the case? I mean, why is it that the quintessential subject of racism in our context has largely been gendered as male? And that's not been the case across the Americas that also had a history of slavery. And, you know, the only thing that I can really think of is that the way that we have framed the primary moment of racism as lynching has actually been a gendered moment that creates a certain subject that is somewhat different as it travels throughout the Americas. I'd say the contemporary question is not so much affirmative action, but the way that anti-racist discourse, particularly that is focused on African Americans, has now been framed in terms of black men and boys. And there is a lot of there, but there's also a lot of there that's not on that table, namely what's happening to women and girls. So that's been a real interesting dialogue that we've been having with Brazilians.
And we have 3 minutes, yes, to your question.
Thank you. Thank you, panelists. My name is Ade Johnson. I'm a second year here. I actually have a question from our journal members, so I'll just read it. The Shoot v. Coalition for Defense of Affirmative Action case, we actually wanted to get your opinions about that case. And for those of you who don't know, the case involves Michigan State's Proposal 2 ballot initiative, which would change their constitution to eliminate race-conscious admission procedures, specifically preferential treatments.
Do you want to take
the Sweat case? So why don't we take the last question? And they will, okay, I'm going to take all 3 questions and let the panel wrap. Yes, because I want to keep this on time.
Okay, my name's David Harris. I'm from
Cutting into your break.
New Jersey. When affirmative action was first started, at least because I was there when it first started, one of the arguments for it was that it was America was a place of upward mobility, and that at that time black people were left out of upward mobility, and we needed these programs. America is now number 2 in upward mobility in the world, and even the race-based affirmative action programs aren't addressing it. And I'd like to hear the panel's comments on that.
And the last question.
Yes, Reverend Ricky Nelson Jones, 20-year civil rights attorney, my law office in Baltimore City, 1988 graduate of this law school. What I want to ask about is this. The international treaty is clearly saying find discrimination and deal with it. However, in the Shelby case, the United States Supreme Court spent a lot of time talking numbers to present this as if it wasn't a race issue. And then in Latin America, theoretically, they don't think we have any race issues. I want to know from the 3 of you, do you have some idea of how we take this from the sky in theory, that is the international treaty idea, bring it down to the earth so a civil rights attorney can use it, short of getting new justices on the United States Supreme Court?
All right. Well. Okay, now. All right, quick 1 minute.
I'm going to focus on the class and race question. It is true that we have a serious class problem in the United States that we haven't talked about as a class problem, and it crosses across race as well. But I think it's because we have asked race-based affirmative action to do much more work than it was ever devised to actually do. We have very narrow perspectives about what race-based affirmative action can handle, and we've devised our programs very narrowly. So to say, in some respects, it's too early to make judgments about its ineffectiveness because we actually haven't sort of tried it on for size in its most comprehensive fashion. And so the last thing I'll say about that is that those who have suggested that we should instead move to just sort of pure socioeconomic status-based affirmative action programs, what that loses sight of is that in places where you've had natural experiments with this, Cuba, for instance, the natural experiments show that when you don't focus on race at all as race, that class programs still leave race-based hierarchy in place. You don't address race discourse, if you don't address race ideology, then you leave in place people's very biased perspectives that can continue to maintain the legacy of racial discrimination.
Thank you. I'm going to take a stab at the last question. And I would say, I think that some of that stuff is actually already happening. Through organizations like the Lawyers Committee, I know that the Leadership Conference also, over the past, let's say, 20 years, looking more seriously at particularly the Race Convention and how to frame the struggle that in the United States is termed civil rights, how to actually frame it as a human rights struggle, making us part of the international community rather than an outlier. I would suggest that also you look at places like Chicago in terms of looking for success. As it related to the Burge torture trial, where you had a commander on the south side of Chicago who routinely tortured black men for 20, 30, close to 40 years. Got very little traction, only relying upon the municipal government. You had a group of lawyers who were representing the torture victims go to Geneva, put it on the agenda of the CERD committee. The CERD committee issued a recommendation. They took that back to Chicago, and it was, as a result of that, Burge was not only charged, he was convicted, he was sentenced, and there is the possibility of monetary remuneration in addition to any time that he might in fact serve for torture that up until that point had gone largely unacknowledged and unaddressed. So I'm not quite as pessimistic as you. I see places where it can in fact be used.
Okay, Barbara, I know she's mindful of the time, so I'm going to try to talk really fast. On the race, class issue, and affirmative action. I come from one of the institutions that actually tried to substitute class-based affirmative action for race, and it was a disaster. And it was a disaster for some pretty obvious reasons. First of all, you know, a class-based approach does bring new students into the class, and it does a good thing, so I'm not against it. But it doesn't do anything to deal with some of the race-based barriers, particularly that are reflected in standardized tests. So standardized tests, there is a race gap that still exists even when you control for class. So elite African Americans who are coming from the best schools still have a gap, as well as those who come from less elite schools, still there's a gap between white and black test scores. So if an institution is dead set on relying on test scores, that gap is still going to play a role even if you have a class-based strategy. So that's the one thing, and we don't have to be necessarily concerned or ashamed about that, because now we have more research that tells us that those gaps have nothing to do with ability. If anything, they have everything to do with stereotype threat, the entire environment that produces actual conditions that affect how African American students will perform on a test. If you tell them they're doing an aptitude test, they perform several points lower than they ordinarily would on that same test. So it's not a skills gap, it's the threat in the air. And the last thing about Ncuti, I'll just say that I think that this is probably more important than almost any other case, with the exception of Shelby, because it has to do with whether the majority can essentially gang up on us. Even after we've been able to use the political process, we've been able to persuade administrators and our representatives that a certain kind of remediation is necessary. If the majority can simply come back and overwrite and overrule the normal political process, then it won't stop at affirmative action. It could be anything.
Thank you. Ladies and gentlemen, please join me in thanking our great and amazing panel. Amazing. Oh, thank you. Thank you. Wonderful. Thank you, Sandra Hernandez, Lisa Cruz Robinson, Tanya Williams Crenshaw. Thank you so much. I just want to, as we get ready to break, we're going to resume. Dean Dark, we'll resume at? Okay, we'll resume at 11:15. For those of you who wanted to know about Galedes, it's spelled G-E-L-E-D-E-S. Galedes, it's an amazing organization. It's on the web. You should look it up. Also, I wanted to give recognition to John Doyle, who is another one of those Mississippi volunteers who has joined us. Thank you, John. Thank you for your amazing decades of service. Thank you. Thanks, everyone. Wow. That was fun. That was excellent. Thank you. Wow, we did 2 hours. Wow. We did 2 hours. That was wonderful. Thank you so much. Thank you. That was a lot of fun. A lot of fun. Awesome. I mean, you talking about this is serious CLE. Yes. Okay. That was amazing.
Hello. We're gonna start in about a minute. The next panel.
Professor Olivares told me to wait till she gets situated. Yeah. Okay. Good morning. We're about to get started with our next panel. Okay. Good morning. My name is Cornisha Brooks. I'm the Executive Publications Editor of Volume 57 of the Howard Law Journal. Our next panel is Hitting Borders, Opportunities and Obstacles for Immigrants' Rights. This panelist will be discussing the most pressing legal issues affecting immigrants in the United States. This panel will be moderated by our very own Professor Mariela Olivares. Professor Olivares is an assistant professor here at the law school and teaches torts, immigration law, family law, and a domestic violence seminar. Her professional and scholarly interests include the intersection of family law, domestic violence, and immigration law and policy, including access to justice for immigrants in limited English proficient populations. Ladies and gentlemen, Professor Olivares.
Good morning. Good morning, everyone. Thank you all for being here, and I really want to give a special thank you to the members of the Howard Law Journal who have worked so incredibly hard for a year, as Dean Dark told us earlier this morning, on this symposium, and so we're just so grateful that you all are joining us today. I'm very excited to be moderating this panel today. The panel is going to be reflecting on immigration law and policy challenges up to this point and the current framework and status of those challenges, including recently introduced proposed legislation in Congress concerning comprehensive immigration reform. Indeed, comprehensive immigration reform, that is, reform to the current state of immigration law and policy, was a hallmark of President Obama's 2012 re-election campaign. And his administration has been, has been, making efforts to, quote, fix the broken immigration law and policy systems to some positive and many have said negative consequences. Members of Congress were and still are meeting to try and compromise and propose legislation that would get at resolving or at least lessening the myriad problems that we've seen with the current range of implementation practices of current law and policies. We haven't heard about it quite so much recently because of other crises du jour of the federal government, but focus has shifted away from immigration law reform, but it's only a short matter of time before we are again vigorously debating these issues. So our panelists today will discuss various issues of immigration law reform and policy. We'll hear from each of them and then take questions and comments from the audience. We'll begin with Alejandro Reyes, counsel for the Legal Mobilization Project and Immigrant Rights Initiative at the Lawyers Committee. He's at my far right. There, Mr. Reyes works on pressing civil rights issues related to fair housing, voting, and immigrant rights. And prior to joining the Lawyers Committee, Mr. Reyes was an attorney with the Migrant Farm Worker Justice Project, handling federal class action lawsuits, and was an Equal Justice Works Fellow with Gulf Coast Legal Services, where he advocated on behalf of migrant farm workers and other immigrant groups. And he's an alum, woo, of the law school. Mr. Reyes will speak about reform, immigration reform, as it relates to guest workers today. Second, to Mr. Reyes' left will be Cesar Cuauhtemoc Garcia Hernandez. Professor Hernandez is a visiting professor at the University of Denver Sturm College of Law and an associate professor at Capital University Law School in Columbus, Ohio. He publishes Crimmigration, that's kind of hard to say, I never thought that, .com, which is a nationally recognized blog about the convergence of criminal and immigration law. His academic interests center on crimmigration, and he writes and teaches about the right to counsel for immigrants in the criminal justice system, immigration, imprisonment, and race-based immigration profiling. Professor Hernandez will provide another view of current problems with system actors discussing the U.S. system of detaining immigrants. Then we'll hear from Professor Shobha Wadia, to my immediate left. Professor Wadia is a Samuel Weiss Faculty Scholar at Pennsylvania State University's Dickinson School of Law and the founder-director of Penn State Law's Center for Immigrants' Rights, an immigration policy clinic. She researches the role of prosecutorial discretion in immigration law, the association between detention, removal, and due process, and the intersection between immigration, national security, and race. She is a nationally recognized expert on the intersection of immigration law and prosecutorial discretion, topics about which she will discuss today with us. Finally, we'll hear from Professor Elizabeth Keys, a professor at the University of Baltimore School of Law, where she directs the Immigrant Rights Clinic. She supervises students in a range of complex immigration cases and immigration policy projects. Before teaching, Professor Keys worked here in the DC area, representing immigrant clients and worked alongside organizers and social workers on issues ranging from domestic worker rights and human trafficking to domestic violence. She will speak with us today about her research on the role of narrative in immigration law and policy reform and how this affects certain groups of immigrants facing reform. So with that, I'm excited to turn it over to Mr. Reyes.
Hi. I assume I have your polite attention. I'm going to ask for more, if that's okay with everyone. How many of you passionately care about guest worker issues? Raise your hand. Go to bed and this is what you're thinking about. You wake up angry. All right, challenge accepted. Let's get started. I want everyone to imagine a job you've had in your life, either a job you have now or a job you've had at some point. Is everyone imagining a job? All right, let me hear some. Let me hear some of these jobs. Don't say attorney, say something else. Paralegal. Paralegal. Waitress. Computer specialist, waitress, I heard. Like, okay, excellent, all right. All right, I want you to imagine that this is your job you have right now. It's the only job you have. It's the only ability you have to provide for yourself, to care for your family. This is the only job you have. You can't get another job. This is it for you. Now imagine that you're not treated very well. Either it's sexual harassment, either it's wage theft. All right, and what are you going to do about it? What can you do? Imagine a world where you can't do anything. Your choices are to keep working or to lose your job and go home. Now also imagine this job, the job you're thinking about right now, you don't have it here in the US. You have it in China, let's say. You don't speak the local language. So let's say you want to do something. You want to get help. You don't speak Cantonese or Mandarin. What are you going to do? And your family is depending on you. What I'm describing to you are the lives of hundreds of thousands of guest workers that live in this country, that our laws allow employers to apply for and bring to perform jobs here. Now, I should begin by saying guest workers. What we're talking about are temporary workers. An employer can't find a U.S. worker. They can't find a single U.S. worker. How many people live in this country? Anyone have any idea? 300. Okay, they all can't work. I have a newborn. She can't work. So not everyone can work. But we're talking about hundreds of millions of people in this country. An employer cannot find a U.S. willing worker. And so they post a job. They don't get any replies. And so reasonably, they go to the Philippines, or they go to Jamaica, or they go to Mexico. This is the most logical step if you can't find someone to work at your business. You go overseas. Now you bring this worker on board. And the special thing here, what we talked about a moment ago when you imagine this job, You can't change jobs. You are tied to this job. You can't say, I'm unhappy with my working conditions. Now imagine the job we just talked about. Let's say you were promised $10 an hour and you're getting paid $1 an hour. Would that make you happy? Would that make you a better worker? Well, guest workers face this every day in this country, and there's very little they can do about it. So now let me give you some more perspective. I'm going to talk about two types of guest worker programs we have in this country. So these programs exist. We're not talking about unicorns. This is real. Although my daughter believes we do have unicorns, so you never know. The H-2A guest worker program is for farm workers. If you are a grower and you can't find willing Americans to harvest, whether it's citrus or vegetables or fruit, you can petition and bring in foreign workers as farm workers. The H-2B program is for non-farm workers. Non-farm work, anything that isn't farm work, essentially. Now, we're going to do a quick pop quiz. I just want you to answer, well, let me first tell you what the protections H-2A workers have, and then we'll do the pop quiz. Got ahead of myself. Farm workers. These are the protections migrant farm workers have when they come over here as guest workers. There is a 3/4 guarantee. This means that if the grower lets you go, they have to pay you for 3/4 of your contract. So let's say typically a contract is valued at $10,000. They need to pay you $7,500. They can't just let you go. You have an actual contract, an employment contract. It's a protection for the farm worker. There is free housing and meals. And if meals are not provided, they have to provide cooking facilities. If you are a guest worker doing farm work, you can get assistance through Legal Services Corporation, LSC. What this means is that legal aid to get federal funding, they can assist you. There's a 50% rule. What this means is if you are a U.S. worker and you show up on that farm right below halfway through the season, the farmer has to hire you as a U.S. worker. There's preference for the U.S. worker. The design of these programs is not to displace U.S. workers. The design is an employer can't find willing U.S. workers, and so here is another avenue. Now, H-2B workers are non-farm workers. So here's the pop quiz. All right, 3/4 guarantee. Do H-2B workers have a 3/4 guarantee? Yes or no? No. I'm going to give you a tip. All the answers end in no. Do H-2B workers get free housing? No. You can say it like you mean it. You said you were passionate about guest worker issues when we started this. Is there a 50% rule protecting U.S. workers? No. Cooking facilities if no free housing is provided? No. That's the life of an H-2B worker. They don't have any real protections. Now, as you can imagine, the reason employers have to go to Mexico or the Philippines to bring H-2B workers is because no American will do some of these jobs. What type of jobs do you think H-2B workers do in this country? Pretty much anything. So I'll give you an example. There are no Americans willing to do construction work in this country. There are no Americans willing to do landscaping work in this country. There are no Americans willing to take hotel jobs, housekeeping. There are no Americans willing to work in restaurants as waiters or waitresses, according to some of these companies that bring in foreign workers to perform these jobs. As you can imagine, our unemployment is not 0%. Now, and I'll give you one real example, and I'm not implying that this company did anything wrong. This is on the DOL website, Department of Labor website. In 2012, the following business brought in several hundred H-2B workers. The Breakers in Palm Beach. Anyone familiar with that hotel? It's a very luxurious hotel on the Atlantic Ocean. It's a beautiful, beautiful hotel. I've never stayed there. It's gorgeous. They didn't bring any this year. There was some press involved in Florida. But the Breakers couldn't find several hundred Floridians to work in this hotel in housekeeping. All right, so why would an employer want to bring in a foreign worker? What could they possibly gain from bringing in a foreign worker? For some employers, the ideal employee is someone who is never going to complain, even if they did complain, couldn't find assistance, and if they finally continue to insist on complaining, they could ship out of the country. For some employers, that's an ideal situation. And you also have to think about this workforce. They come from communities that are impoverished. They may not have attained a high level of education. earning something here is more than they would have earned at home. So this is a easily exploitable population that we permit employers in this country to bring in. And I'm not saying all employers. Certain employers do. So what can we do about this? You know, the theme here is obstacles and opportunities. We talk about immigration reform, and there are some opportunities. There's a W visa program that came out of the Senate, the bipartisan bill, and the program would allow unskilled workers to be brought in on 3-year visas. After 2 concurrent 3-year visas, they could apply for legalization, and they could also bring in family members. So as an employer, here you have another option. I can bring in unskilled workers, and this program is somewhat better. There's a process to file complaints. There would be a new bureau created to administer the program, to monitor trends in migration so that they could either increase or lower the cap. I didn't mention this previously, but there's a cap on H-2Bs. Only 66,000 can come in under the H-2B program per year. Has anyone ever heard of an H-2R visa? H-2R? All right. So what's really interesting about some of the rules we have is that the H-2R visa is used so that you can bring back returning H-2B workers and not count them against the cap. So the Senate plan, we don't know what's going to happen with CIR. The Senate plan is an improvement. But here's the catch. In the Senate bill, an employer has 2 options. Use the W program, which is improved, has better protections, or still use the H-2B program because it's still on the books with no additional protections. I understand my time is about up. I hope that I've encouraged you to become very passionate about reform for our guest worker programs. We deserve better for Americans, also for the workers that we bring into this country.
Good morning. Good morning. I want to thank the folks who made my visit out here possible, especially the editors of the Howard Law Journal who have organized the symposium and actually been extremely efficient and on top of things in the organizational process leading up to today's event. So I really do appreciate that and was thoroughly impressed by Ms. James's opening remarks this morning, which set the bar high, very high, and I hope that I will be able to at least approximate the comments that she made. So about, I do not mean that to be a joke either. I did think she set the bar quite high. So about 45 minutes ago or so, I'm just looking at the clock, President Obama wrapped up some remarks about the state of immigration law in the United States. He did this in a White House ceremony with Vice President Biden at his side. And one of the things that he said, at least if my Twitter account is informing me correctly, I was sitting in the audience with you all, is he said, immigration reform, it's good for our economy, good for our national security, and we should do it this year. Well, I agree that we should do it this year. I agree that it's good for our economy. I agree that it's good for our security. One thing that President Obama did not mention, though he could have, at least I don't think he mentioned, again, I'm relying on Twitter for my information right now, is he could have said it's also good for the economics of the national security industry. In January of this year, the Migration Policy Institute, which is a very, very well-respected research organization based here in Washington, D.C., issued a report in which it described the nation's, quote, formidable immigration law enforcement machinery. Now, this is a policing machinery that in a country that spends billions upon billions of dollars and has devoted countless hours, human hours, to devising the most efficient and most powerful law enforcement mechanisms that come to my mind, at least, or among the most powerful that come to my mind. I don't want to get overly hyperbolic. The immigration law enforcement machinery that we currently have in the United States is indeed second to none, with a total cost of about $18 billion every year. It's a law enforcement machinery that features border walls that are literally made of steel and concrete. It features armed sentries manning those walls. It features military, yes, military reinforcements. And yes, it features drones of the Predator variety. That's their name, Predator drones, the same kind that tend to fly over Afghanistan, Iraq, and other places where we have expressly launched or deployed our military. They do fly over border communities. My focus, though, is on a different aspect of that immigration law enforcement machinery: detention. The immigration detention system that we have in the United States today is of gargantuan proportions. Today, or last night at least, there were about 33,000 people sitting in an immigration detention center somewhere in this country waiting to find out whether they will be allowed to remain in the United States or not. We will see a repeat of that tonight. Over the course of the year, we're likely to see an excess of 400,000 people who at some point spend a night sitting in an immigration detention center. This doesn't come cheaply. It comes at a cost of well over $2 billion, just $2 billion a year, all of whom are waiting to find out whether they will be allowed to remain in the United States. Meanwhile, another 20,000 or so will be confined as punishments for having been convicted of some immigration-related crime. The two principal federal crimes that I'm talking about are the crime of unlawfully entering the United States, or the crime of unlawfully re-entering the United States. The first is a federal misdemeanor, the second is a federal felony. About 30% of all of the inmates who entered the federal prison system in fiscal year 2010 were placed there because they were convicted of some immigration-related federal crime. Between 1995, just to give you a sense of how big this population has grown, in 1995 there were about 91,000 people who were confined, either because they were being prosecuted for an immigration-related, a civil immigration-related violation of immigration law, or because they were being punished for having committed one of these federal crimes. By fiscal year 2010, that 91,000 had grown to 383,000. This is not a blip. In the last several years under President Obama's leadership, as well as the latter stages of President Bush's leadership, have attested to the fact that this is in fact a trend. And my interest is in trying to determine why it is we've come to rely so heavily on detention to enforce immigration law. My contention is that we've incentivized the creation and the maintenance of a detention regime through distinct but dependent means. First, we adopted a rhetoric of treating immigrants, of viewing immigrants as criminals. And secondly, in response, we've developed a pool of invested actors that deal with this threat, or this ostensible threat. So if we go back to the early 1980s, we begin to see the hallmarks of this rhetoric of criminality. And the best example is when we had a large group of Cubans who left from the port of Mariel and came to the United States. The media and policymakers quickly labeled these as the outcasts from Castro's prisons. And so we became very, very scared. Those of you who don't know much about immigration law history but do like TV may remember this in the form of Al Pacino in Scarface. He was supposed in that movie representing one of these folks who comes from the port of Mariel to wreak havoc on the United States. we begin to use imprisonment in response to that wave of immigration. We use the Orange Bowl in Miami. We use federal prisons spread throughout the country. And we give birth to a trend that hasn't subsided of expanding the types of immigration activities that constitute crimes, while also expanding the list of crimes that can result in immigration problems, with a special focus on drug activity. The Anti-Drug Abuse Act of 1986, which gives us mandatory minimums, 100 to 1 crack cocaine disparity, now 18 to 1 crack cocaine disparity, drastically expands deportation for drug crimes. A few years later, the Anti-Drug Abuse Act of 1988 introduces into immigration law the concept of the aggravated felony, which penalizes 3 crimes: murder, drug trafficking, and trafficking in firearms. And it also institutes a regime of mandatory detention that has come to become emblematic of the modern immigration law enforcement machinery. The result is an association between criminal activity and immigration activity. It's emblematized by a statement that President George Bush made when he signed the Immigration Act of 1990. He said, "This act meets several objectives of my administration's war on drugs and violent crime. Specifically, it provides for the expeditious deportation of aliens who, by their violent criminal acts, forfeit their right to remain in this country." Al Pacino comes to mind. That was 1990. We fast forward to 2012, and the only mention of immigration that occurs during the presidential debates, President Obama claims that his administration targets, quote, criminals, gangbangers, people who are hurting the community. Now, there's plenty reason to cast doubt on the accuracy of that statement, but there is little reason to doubt the association, that the association between criminals and immigrants continues to resonate with policymakers at a prominent level of our federal lawmaking, including Speaker Boehner and others in the Republican leadership. Speaker Boehner, in April of 2013, when ICE, the Immigration and Customs Enforcement Agency, decided to move some detainees into alternatives to detention, criticized ICE for doing what he said, letting criminals go free. Now, he had no information about who these people were. He had no information about whether they, in fact, had criminal histories or whether they were, in fact, dangerous. But facts get masked by perception so often, and perception drives policy. In response, we've developed a set of invested actors, people who are very interested in maintaining the immigration detention network. The private prison corporations come to mind as one. Corrections Corporation of America and the GEO Group are the 2 largest private prison companies operating in the United States, both of which got their starts with immigration contracts from the former INS, the Immigration and Naturalization Service, in the mid-1980s, and that now reap tens of millions of dollars of revenue from contracts with DHS, with the U.S. Marshal Service, and the Federal Bureau of Prisons to house immigration detainees. Meanwhile, local cities and county governments have also gotten into the immigration detention business by building their own facilities with the hope that ICE will come along and give them a revenue stream. The problem is, sometimes they build these facilities, and, well, there are moral problems with that, but there are also financial problems. Sometimes they build these facilities, and ICE doesn't come. One, just to give you a very quick illustration of the response from county officials when they see that their prisons are going unfilled, and prisons that they were counting on for economic development, they say, was a statement by the chairman of the Irwin County Board of Commissioners, this is in Georgia, who said, If it closes, then everybody loses their job and the inmates go back to wherever they came from, but we hope that it never gets to that. Those are people who they're hoping will provide the economic engine of that county's future. People locked behind bars. This is, of course, not a new story. We've seen this story for generations in the criminal context, but I think that is in fact my point. That we have seen the way that this criminalization and monetization of people who are accused of engaging in criminal activity and of endangering our communities, we've seen where that takes us. We've seen that in the drug war context, and my concern is that we're seeing that happen now in the immigration context and letting it happen. Thank you.
Good morning. Thank you to Richard Branton and the entire Law School Journal for inviting me to speak today. Speaking at Howard carries a special meaning for me. I first learned about Howard Law School when I was in junior high, and I was reading one of those second-rate biographies about Thurgood Marshall. And I thought to myself, oh, Thurgood Marshall went to Howard Law School. I want to be a civil rights lawyer. Like many of my early ideas for social justice came from the late Thurgood Marshall. It makes it even more enriching to have his wife here today. Fast forward to 2008, I also had the privilege to teach immigration law at Howard Law while I was living in Washington, D.C. and practicing as a lawyer. This morning, despite the pressure of being the panel that stands between lunch, I am going to provide a 101 on the role of prosecutorial discretion in immigration law, which is my primary area of research and fundamental to understanding how the immigration system works. Prosecutorial discretion is a largely invisible tool that enables thousands, if not millions, of unauthorized non-citizens to reside in the United States without the fear of deportation. It may be characterized as invisible because prosecutorial discretion decisions are largely connected to no action at all, or what some might call non-enforcement. A favorable exercise of prosecutorial discretion refers to a decision by the Department of Homeland Security or a DHS employee to abstain from enforcing the immigration laws against a person or group of persons. A grant of prosecutorial discretion does not lead to a formal legal status, but rather results in a tenuous one. There are two or maybe three theories behind prosecutorial discretion. The first is economic. The agency has the monies to deport 400,000, and it has, or less than 4% of the total removable population. So prosecutorial discretion acts as a management resource tool for the agency. The second theory of discretion is humanitarian. There are people who are here with low priorities or high qualities, those who are coming to pursue higher education, young men or women engaging in the military, single mothers acting as primary breadwinners and caregivers, and migrant farm workers who have left their families behind to build a life for themselves and are contributing to the United States in meaningful ways. They should be protected from deportation, and prosecutorial discretion often acts as a humanitarian tool in this way. There is a possible third theory that I might characterize as more political in nature, and that is when the agency chooses to exercise executive power in the wake of congressional inaction or congressional action we don't like. More on that in a minute. So exactly what does it mean to exercise prosecutorial discretion, and at what stage of the immigration enforcement process may it be exercised, right? Very important practical questions. While you might have heard the term prosecutorial discretion and associate it with only one form or one action, there are in fact more than 20 different kinds of prosecutorial discretion in immigration law. Some have more fancy names than others, right? So, for example, deferred action for childhood arrivals, or DACA. That is one form of prosecutorial discretion that the administration chose to implement for a particular class of individuals. A less fancy form of prosecutorial discretion is when DHS refrains from filing a charging document with the immigration court, and when this notice is otherwise filed, a person is placed in removal proceedings, right, and is all at once placed in an adversarial form at which the government has alleged removability, and the judge will hear arguments, hopefully, around someone's eligibility for relief. Think about the prosecutorial discretion decision to not file the charging document. Thousands of dollars are saved, right? Labor and time from the attorney, time from the trial attorney, which in this case would be the Department of Homeland Security, time for the judge, travel by all the parties, bringing in witnesses, shame to the non-citizen for having to be in a court proceeding. These are some of the things that a person is protected from when a document is not filed. Another way DHS may exercise prosecutorial discretion is to release one of the 34,000 non-citizens from detention, right? Our clinic is representing a client from Ghana who's in York County Prison. That was my stop en route to Howard School of Law yesterday, and he is married to a U.S. citizen, has 2 young U.S. citizen children who are close to the ages of my own children, and he has a drug conviction that is minor, arguably, and for that reason should be perhaps released as a matter of prosecutorial discretion because of his family relationships. That's another way that DHS can exercise prosecutorial discretion. Even after someone is placed in the system or put in removal proceedings, an ICE trial attorney can move to dismiss an immigration case, or once a non-citizen has been afforded relief, can choose not to file appeal. These are other forms of prosecutorial discretion. This kind of discretion enjoys a very rich history. The practice of prosecutorial discretion has existed for as long as the immigration system has. And for those who are not history buffs but like music, let me share with you that the policy of prosecutorial discretion was first revealed in connection with the immigration case of music legend John Lennon. He had a drug conviction, and his attorney, who still practices law in New York City, sued the agency to find out about whether or not there was some type of policy like prosecutorial discretion, then called non-priority status, a form of deferred action, to place cases on the back burner. And what was revealed through the John Lennon lawsuit was a policy with the unfancy name of operations instruction that said that deferred action could be granted for people who had features like long-term residence in the United States or a serious medical or mental health care condition. Even after the operations instruction was repealed, former INS Commissioner Doris Meisner issued a memo on prosecutorial discretion in 2000. And for the entire decade, from 2000 through 2010, this was your bedrock memo, if you will, on prosecutorial discretion. This Meisner memo also offers a good illustration of the executive acting when Congress has produced a piece of legislation that we, advocates, may not like, or where Congress has not acted. So in 1996, there were 2 immigration laws that were passed by Congress that eliminated the discretion in many ways from immigration judges and also increased the grounds of deportability for certain conduct. These were also alluded to by the former panelist. Well, in many ways, this Meisner memo was a reaction or a response to these 1996 immigration laws. After 9/11, Congress swiftly, I know it's very hard to imagine after a 16-day furlough, passed another bill called the Homeland Security Act, abolished INS, and assembled a brand new cabinet agency called the Department of Homeland Security. And this department has 3 major immigration players, all of whom have the authority to exercise prosecutorial discretion: Immigration Customs Enforcement, ICE, Customs Border Protection, CBP, and Citizenship and Immigration Services, CIS. So you do the coordination math. For the administrative law buffs in the room, appreciate the fact that nearly every single document INS and DHS has issued on prosecutorial discretion is a general statement of policy. It is sub-regulatory. It is not legally binding. For the criminal law buffs in the room, appreciate that immigration prosecutorial discretion bears some striking resemblances to the criminal system, right? There are many criminal law-like features in the immigration enforcement process, such as arrest, interrogation, detention, trial. These are also points at which prosecutorial discretion may in fact be exercised by prosecutors in criminal law. So appreciate this resemblance. Now let me fast forward in the negative 30 seconds I have left to the last few years and highlight the role prosecutorial discretion has played during the Obama administration, right? Early on in 2008, we saw this great commitment to comprehensive immigration reform, and nothing happened. And then there was a piecemeal effort to pass a piecemeal but compelling measure called the DREAM Act, and it failed on a vote in late 2010. So you have a stalemate in Congress. You have angry dreamers. You have shocked immigration advocates, all rechanneling their pressure away from Congress and to the administration to do the right thing. A humanitarian crisis was in the face of immigration policy, right? We had a record number of deportations, and something needed to be done. Enter in a medley of memoranda, as I have coined the phrase, from ICE about its policy on prosecutorial discretion, and DACA, Deferred Action for Childhood Arrivals. Whether you think these more recent actions are political in nature or not, appreciate that the legality of them dates all the way back to John Lennon, if not earlier. Rather than offer some solutions on how to address every injustice in the immigration system and the ways in which prosecutorial discretion provides a Band-Aid to those injustices, let me just share a few specific to immigration prosecutorial discretion. First, DHS should increase the transparency about the cases that are processed for PD. Interests you, I've got a couple law reviews on my great FOIA adventure and quest to get this information. Second, DHS should hold employees accountable when they abuse their prosecutorial discretion and create more incentives for ICE attorneys and DHS attorneys to do the right thing. Third, DHS should issue fewer notices to appear or charging documents against non-citizens who do not fit within the administration's highest priorities. And finally, though we didn't get to talk about this particular remedy in great detail today, but again, it's in another law review, DHS should codify deferred action, a particularized form of prosecutorial discretion, into a rule subject to notice and comment rulemaking under the APA. Thank you for your time. I look forward to your questions.
Good afternoon. I got the first good afternoon. No pressure being the last person between you all and lunch. I want to start by thanking the Howard Law Journal, who have been, from the beginning, so professional, just consistently through the process, and then so warm and wonderful in your welcome today. So thank you. Thank you so much for inviting me to be part of this panel. I have been writing generally about how immigration law and practice is slowly narrowing the ways in which people, especially poor people and immigrants of color, can become American. And I mean that not in the legal sense of citizenship, although that matters, but more in the sense of feeling and being seen as members of our society deserving of rights. The path toward worthiness increasingly requires, the path toward citizenship and membership increasingly requires a high level of so-called worthiness. And today, I want to focus on how some of this narrative of worthiness is showing up in the immigration reform proposals themselves, and how reform may reward the so-called worthy at the expense of our relatively more inclusive tradition of immigration. And I want to specifically connect that issue with comparable issues facing communities of color more generally, whether immigrants or citizens. We see echoes of this in issues that have faced African Americans for a long time. To name a couple, welfare reform in the 1990s talked about deservingness and worthiness, and we hear it today in felon disenfranchisement and voter identification laws. As critical race scholar Kevin Johnson, UC Davis Dean, has said, immigration law is a, quote, helpful gauge for measuring the nation's racial sensibilities. He calls it a magic mirror by which we can see how America wants to treat its own citizens of color. Moving away from a history of inclusion in immigration law, I believe, mirrors something similar happening beyond the field of immigration. But first, you've been passionate about farm workers, detention, prosecutorial discretion. Now you're going to be passionate about immigration history. So for starters, calling our immigration tradition inclusive is itself somewhat misleading. People have always been excluded on the basis of race. First, Africans brought here and denied anything like full membership. I need say no more. Then in the 19th and early 20th century, Asians were explicitly barred from entry, explicitly barred from acquiring citizenship. In the 20th century, Mexicans experienced de facto barriers to citizenship, to entry into citizenship, as did others. But our mythology about immigration is powerful, and it is one of an America that is open to all comers, those who had little where they came from, but who come, work hard, and help build the country. That's the story we tell. The history even has a soft spot for criminals. The stories of the ne'er-do-well who fled the law in the home country, came here and reinvented themselves. A story of second chances that is part of our mythology too. The mythology came close to alignment with the Immigration Act of 1965. And that act is credited with changing the demographics of America, nothing more or less. The act was very much inspired by the civil rights movement's emphasis on removing color barriers from our laws, and the legislators themselves saw themselves as drafting another piece of civil rights legislation with the act. I believe that much as other civil rights era achievements are being rolled back in today's political climate, the civil rights achievement in immigration is likewise rolling back. It's a process that began a while ago. We've seen an escalation since 1996, as has been noted, in the unwillingness to forgive crimes, even minor ones, committed by immigrants. And our immigration system gives those folks very few second chances. Security concerns since 9/11 slammed the doors closed for many Arabs and South Asians who were here lawfully and peacefully, and closed the door for others who aspired to come. And even poverty has itself become deeply suspect. Public benefits were taken away from immigrants, lawful ones included, in 1996, and working without authorization has, in the last 10 years, opened people up to deportation, first through very militaristic style raids on workplaces, and more recently through the less dramatic but equally potent audits of workplaces that bring undocumented individuals to the attention of immigration authorities. So we've had this context, and now we're discussing immigration reform. So, immigration reform is theoretically fixing a problem affecting roughly 11 million people who are particularly from communities of color in the US. There is much in the bill that is exciting and good, but what is clear is that it will exclude many, many, especially from marginalized communities of color, as the framework shifts from that 1960s framework of inclusion and openness to one that is based more on the sense of worthiness. So who are these who will be left out? Estimates from the government itself suggest that 3.5 million of those 11 million will not be included in immigration reform. This is not the fix we're hoping for. One reason that they will be left out, some, is that the reform is not available for those with a series of criminal convictions, perhaps an aggravated felony, which, as you've heard, went from some very serious crimes to including a large number of much more minor crimes, to 3 misdemeanors. 3 misdemeanors, drunken disorderly, trespassing, you're out for immigration reform. How is that a community of color issue? I think the connection is clear when you have communities that are over-policed, people of color being disproportionately arrested and convicted. Those are the people who are disproportionately locked out of the benefit of immigration reform. Another set of people are going to have a very hard time staying in the pipeline for the status that immigration reform will provide. The process to actually legalize will take between 10 and 12 years, during which time they must stay employed consistently with only a 60-day gap between jobs permitted during that time. There's exceptions for illness and studies and so forth. But when we think about this particular economy and the people who have tough times keeping jobs, we're facing a large problem of people at the lower economic end of the spectrum being able to meet the requirements for immigration reform, and we're creating a new incentive for staying with bad employers, much like the guest worker context, because the consequences of losing a job, leaving a bad job without another one lined up, are simply too great. There are other requirements that will knock people out, but I wanted to focus on those two today. The law itself, so that's how the law deals with those here currently who are undocumented. The law also shifts who will come in the future, and that's an interesting shift. We see collectively a shift from the conscious decision in 1965 to open the doors to new previously underrepresented populations. In 1965, the law created something specifically called the diversity visa, which allowed folks from underrepresented countries who didn't have relatives who could file for them, who didn't have jobs waiting here, to get a lottery ticket, basically, to get a green card to come to America. That program is being eliminated under the Senate bill that is the most well-articulated version of immigration reform that we have now. Likewise, the 65 Act had plentiful ways to bring family members over and define family fairly inclusively. Those family paths to immigration are being narrowed, and all of those slots, from the diversity visas and the family visas, and the family visas are the ones that really changed the demographics of the immigrants coming to America and brought more immigrants of color. All of those visas are now being given to quote-unquote merit-based immigrants who are given points that are assigned for, among other things, advanced degrees and years of employment experience in certain highly skilled jobs. That's a very dramatic shift. Why does this matter? Shouldn't we be able, as a country, to prioritize the best and the brightest? Oh, 1 minute. It does sound good, but there are two things to be wary of. It's going to create a set of new problems for those left out of reform, that 3.5 million. And there's a problem about the message we send about who deserves full membership in America generally. So first, quickly, the new problems it creates for the most vulnerable, excluded from immigration. Being undocumented the day after immigration reform is going to make the experience of being undocumented today look great, and it's not great. With a national ID card required to work, those without that document will be pushed even farther into the shadows of exploitative employment. Imagine engaging even with the school system without that expected identification card. Parents are going to be fearful sending their children to school if they don't have that card. And a whole separate talk could be given about the hopelessness this would create for undocumented youth who know that education will not open the door to employment in the post-immigration reform era. And then the other thing that I'm wary of is what this means for inclusive generally. First, thinking about crime. Some of the hopefulness about America that I've heard and felt most powerfully from my clients comes from those with the least, but who are working hard. And some of those have had criminal convictions, but have been given a chance to turn their lives around. That's now unforgivable in immigration terms. And the analogy to American citizens at society's margins is clear to me. Mistakes, real and perceived, maybe some flaws in judgment that we would like to think could be forgivable, can be the difference between liberty and deprivation of liberty, incarceration, mass incarceration of black men, disenfranchisement of felons, and so forth. And second, the specific issue of documentation. As I've said, after immigration reform, being without that document is going to make it very difficult to go about life and enjoy membership in society. That rings a very clear parallel for me with the voter identification laws, where the people least likely to be able to produce a document that gives them the right to vote are people of color and poor people. I believe Kevin Johnson was right that immigration is a magic mirror, mirroring how society treats people of color or wants to. And so we want to look carefully at the society we're wishing for in this immigration reform bill. And I just close, I promise, by referencing what Ms. Adams said this morning in your wonderful remarks. Let justice be done, but let what is done be just. Thank you.
Wonderful. Thank you to each of our panelists. That was a great, various views of the issues. So we have time now for some questions, and I know they're very interested to hear any questions or that you would like to pose. Ms. Chitani?
Hi, my name is Brittany Chitani. I'm a 3L here at Howard. I have two quick questions. First, for Mr. Reyes, is there any international pushback on the fight for the rights? It seems like if you kind of take away the incentive for these companies to bring in these workers, then they'll stop the program altogether. So is there any pushback internationally from saying, well, let's fight for your rights, as opposed to let's maintain the jobs? And second, for Ms. Wadia, is that how you pronounce your name? Okay, sorry. Does the Chevron two-prong deference test play as a roadblock or as a bridge, or is it ineffective in this prosecutorial discretion issue here?
Should I go first? So in terms of pushback internationally, there has been, and the example that I can cite is Mexico as an example. And Mexico has taken different steps. So I'll give you an example of the state of Coahuila, who has tried to form a partnership in securing H-2A visas for farm workers, and so that instead of the actual future guest worker getting the job on their own behalf, they go through the local government. And the idea is that the local government will ensure that the treatment of the worker will be just and fair. So it's a case-by-case basis. I think what often happens with guest workers is there's a great deal of fear of even reporting actual work conditions because it is your only gateway for this job. And for that reason, you don't always have a lot of great information on either end. One big push has been on recruitment fees. So CDM, which is based in Baltimore, and they have workers in Mexico, el Centro de los Derechos de los Migrantes, they've done a lot of work to get more transparency in eliminating recruitment fees, as an example. So there's been a patchwork of efforts. I think with any of the issues we discussed, there isn't going to be one single answer.
It may not be exactly a Chevron issue, but Chevron is a good illustration of how deference is given to the executive branch or an agency to make law and policy. So that might be one thing you turn to illustrate how agencies really wield quite a bit of power under law to exercise discretion.
Yes,
I
please.
have a question for any of the panel. Professor Keyes raised the issue that I've been thinking about some. My understanding is that there has been a long tradition of favoring of family members for bringing into this country under the immigration rules, and now there is a discussion about favoring people with degrees or money or something like that. And I'm wondering, is there an appropriate balance between the two very different ideas that minimizes the kind of pain that the family members would obviously feel and yet does something good for the country on the side of the economic development?
I think that's exactly right. I think that's why the bill passed in the Senate with bipartisan support. People felt it had tipped too far toward the family, and there's a sort of non-cynical way to see that. And I have a slightly more cynical view as well. But yeah, the categories they cut were the ones who were sort of the least central to a nuclear family. The married adult children and the siblings are the categories that got cut. That seems reasonable if we can bring in the sort of the best and the brightest. I just want to underscore that that's a very new assigning points explicitly for the degrees and the work experience in very high-level fields. I looked them up, and even nursing isn't one of the fields. I thought that might be one because there's such a nursing shortage, but it's not. It's just something very different we're doing, and I do believe that underlying it for some people is a sense that that's a vehicle for changing what the immigrants who come here look like. So it has very good policy aspects as well. But I think there's also something else that's going on, because one of the harshest criticisms of the family-based immigration was that it created a chain of migration and swamped America with immigrants from certain countries. And I think this was one way people had of fighting back. So there's a lot going on.
I'll just, if I can add a comment to that, at least the proposal for getting rid of family-based fourth preference for siblings has been on the table, if you will, for many cycles of immigration reform. So some of the compromises you see achieved in the Senate-passed bill were some of the discussions that took place in previous cycles. I think one nuance that I would kind of call a family issue in the positive in the Senate immigration bill is how family members of employment-based visa holders are treated. So the bill does go a far way, if we're looking at the Senate bill, for allowing the derivatives of, say, a software engineer coming through the employment-based system to more easily be here without using up visas available on the cap. Historically, and now then I'm going to stop, family-based immigration system the family immigrant visas have taken 2/3 of permanent visas in the overarching system. So I do think that there is a need for some type of redesign.
Quickly, I think it's important to call out this binary between family unification and economic development as a false binary. Family members, in fact, are economic contributors. And so I think Congress's framing of the issue is one that is overly simplified. There is very, very, very little ability to know what somebody is going to do 20 years down the road. Will they start a Google or win a Nobel Prize or what have you? They are nonetheless economic contributors, and even if they don't do that, they still do all kinds of things. I have not won a Nobel Prize, and I will not. I have not started Google, and I'm still an economically productive individual, as are all of you, right? And so I think it's really important to cast doubt on the way, or cast some skepticism on the way that Congress has chosen to pit communities against one another that ought to be natural allies.
Next question.
Hi, I'm a staff attorney at the Lawyers Committee. This panel has been fascinating. I don't know very much about the subject. I think this question is for Professor Hernandez, but I'm not sure. You guys covered a lot of different challenges and topics confronting immigrants and immigration reform. One thing that didn't really come up much, I don't think, was deportation. And Professor Hernandez started to talk about the Obama administration's presumed emphasis on immigrants with criminal backgrounds. What I do know of the deportation policy of Obama is there's hundreds of thousands being deported every year. It's hard to believe that those are all criminals, and I'm curious what the movement is around deportation policy and how that interacts with Obama's emphasis on criminal backgrounds.
So the Obama administration has made a big point of how it is targeting folks who have criminal history, what it calls criminal aliens. Now, as anyone who's familiar with the criminal law system in the United States knows, is that criminal law spans an incredibly broad spectrum. And we can label as a criminal folks who engage in all sorts of activities, from the most heinous to extremely, extremely minor infractions of criminal law, including entering the country without permission or doing so after you were deported once before, both of which have been federal crimes for almost a century. One of the things that the Obama administration has done is it's touted its growing percentage, that under its watch, the percentage of people being deported has grown. But if you look a little bit closer at those numbers, what you see is that the largest categories of crimes that these individuals have committed are immigration crimes, like the two that I just mentioned, traffic offenses, as in motor vehicle traffic offenses, and drug offenses. And again, drug offenses span a very, very big spectrum. So I think it's really important to not take the administration's words on face value, because their incentive is to present a particular tough on crime appearance, and as the history of the drug war has shown us, the people who get caught up in that law enforcement fervor can often do nothing more than commit very minor infractions.
We have about 5 minutes, is that right? About 5 minutes or so? Okay. So why don't we do what the last panel did, take these 3 questions and then have our panelists comment on them. So Mr. Leslie, do you want to?
Thank you all. My name is Zorba Leslie. I'm a 2L here at the Howard University School of Law. I think my question is for you, Mr. Hernandez, but really for all of you. In wake of the Supreme Court's decision in Citizens United, I think we've all shared a concern for the perversion of the political process, the potential for money to pervert that process. Mr. Hernandez, you spoke to what you see as an economic security machinery or an immigration law enforcement machinery. I'd be interested to hear your perception, your sense of just how strong that machinery will be in this current immigration reform process, and how much that will play out in the ultimate policies and laws that come from this process. Thank you.
So let me take the other questions. Then we can. He's my research assistant too, so be nice to him. Okay, Mr. Islop.
Good afternoon, panelists. Thank you for coming. It was a pleasure sitting here and learning. I'm a 3L, so I actually have 2 questions, which I'm actually going to just ask one of them.
Say you get one question.
Okay. It's kind of specifically to Professor Keyes, kind of discussing the history of immigration law. There's kind of a recent trend with especially highly educated immigrants not wanting to come to the United States anymore. And in fact, they'd be more willing to go to like Canada because they have more liberal immigration law. So kind of how does the immigration in our country kind of play out when the immigration well is now drying up?
And let's take the question from Ms. Santayana.
Hi, my name is Christine Santayana. I'm a 2L here at Howard. My question is to any of the panelists. It's really in regards to queer immigrants in particular, and now that, well, I won't say same-sex marriage, but marriage has become available to many queer individuals here in the United States, how that will impact immigration reform going forward, specifically for families.
So can I ask everyone when they respond to limit themselves to 1 minute or less? Even better? Who would like to start?
You can certainly ask.
It's you and lunch, Cesar.
To respond to the question about the role of invested actors, or this is my formulation of the question. The private prison industry since 2005 has spent about $45 million on lobbying, both at the federal and state level. Now, they claim not to be concerned about enacting more punitive statutes. I'm skeptical about that. Meanwhile, what we do see is that the defense spending is going down, and the same companies that sell the Pentagon armaments are also now getting involved in the immigration law enforcement system. The Predator drones that I mentioned in my talk, those are military-grade hardware. The Boeing, for example, had a $2 billion contract to build an electronic fence. It failed. They couldn't do it, but they got paid a lot of money to do it. Those are just some examples. I think they're definitely very interested.
And about the competition from Canada, it's absolutely true, and it's one of the things that was motivating. There you are. It was one of the things that really was helping bring the Senate deal together, was the sense that our immigration system was not nimble enough to attract people that businesses, important businesses in America, were really hoping to attract, and a very real sense that Canada was doing a great job with it. England, or the UK, is doing a pretty good job with it. And in fact, the point system that is adopted in the Senate bill looks a lot like the Canadian system, and it sort of tags some of the categories it creates to external categories of employment that would change based on market need and so forth. So it's pinning the statute to something that itself is a little more nimble in the hopes of getting some of those folks back. So I think that's exactly right.
Would anybody like to comment on Ms. Santayana's question? The last question?
I mean, I'll share a minute and then have Liz complement, supplement. In a large way, the decision in Windsor has already changed the immigration landscape. The Department of State and the Department of Homeland Security were fast and furious, again, unlike so many things in immigration law and policy, in implementing a system by which same-sex couples could file immigration papers with the agencies or be issued visas at the consulate. I mean, the Department of State had a Google chat on this issue, you know, within a month of the decision in Windsor coming down. In terms of how it might relate to the immigration debate, you know, either for symbolic purposes or for practical ones, perhaps an amendment could be introduced, right, to redefine spouse, although I don't know that politically that would happen, or perhaps there could be more specificity on who can file, you know, what constitutes a spouse just for purposes of marriage. So it could be confined to a particular context legislatively.
And one very small aspect, it's not about marriage equality, but just one good thing that the bill does for potentially for queer immigrants is it gets rid of the one-year filing deadline in asylum, which cannot be understated as an accomplishment. My clinic represents a lot of transgendered individuals who've been persecuted since they were young children. And for them to be able to come here and feel safe enough to approach a government official within a year of arrival after a lifetime, literally, of persecution is impossible. And so we litigate those cases in ways that just shouldn't have to happen. And it's a small thing, it's a small population, but in my view, it's just a wonderful accomplishment of this immigration reform bill.
Thank you again to our panelists. This has been really wonderful. I've learned so much.